Good morning, everyone. Welcome to the first day of our oral argument session for the fall here in our magnificent courtroom in Pittsburgh. As many of you know, the Pennsylvania Supreme Court is the oldest Supreme Court in North America. Our roots date back to William Penn's Provincial Court of 1684. And the Supreme Court was formally established pursuant to the Pennsylvania Judiciary Act of 1722. In 2022, we celebrated the court's historic 300th anniversary in Philadelphia, and we are all very proud of our rich history. We sit today in Pittsburgh's City County Building, a 1917 granite Art Deco building which was designed by renowned local architect Henry Hornbostel. The City County Building houses executive, legislative, and judicial offices for both the City of Pittsburgh and Allegheny County. Before we begin, I would like to recognize some of our law students who are here with us today. They are third-year students from Duquesne's Thomas R. Klein School of Law, whose professor, Lauren Gailey, arranged for them to attend our oral argument session today. Students, would you stand if you're not already standing so you can be recognized? We're happy to have you here. We hope that you will find today's arguments interesting and educational, and I hope that none of the attorneys dissuade you from pursuing careers in law. Thanks for being here. Before we hear the first case, I'd like to remind counsel of a few things. Appellant's counsel, please approach the podium when your case is called. I will then give a short summary of your case. You may then begin by stating your name and the party you represent and introducing your co-counsel to the court. The justices are familiar with your cases, so I ask that you avoid any unnecessary recitation of the facts or procedural history, and instead focus on the main issues on which we granted review. Counsel is welcome to rely on their briefs for any particular issues. Please remember that we do not permit rebuttal. In cases where there are multiple parties represented by separate counsel, you should avoid repeating the same arguments as prior counsel. Please try not to interrupt the judges when they are asking you a question, although they may be interrupting you. A justice's question is not meant to trip you up. Rather, it indicates there are particular issues we wish to explore further. While there's no set time for oral argument, I will advise counsel when the court is satisfied that all of its questions have been answered, and at that time, I will ask that you conclude your argument. Mr. Minner, would you call the first case?
Commonwealth of Pennsylvania versus Derek Lee, representing Mr. Lee, Mr. Brett Brody, representing the Commonwealth, Mr. Kevin McCarthy.
Good morning.
Good morning, Your Honor.
In this case, appellant Derek Lee was convicted of second-degree felony murder, robbery, and conspiracy in connection with an attempted robbery which resulted in his co-conspirator shooting a man to death. Appellant was sentenced to a mandatory term of life imprisonment without the possibility of parole for his second-degree murder conviction. We granted allowance of appeal to determine whether appellant's mandatory sentence of life imprisonment without the possibility of parole is unconstitutional under Article 1, Section 13 of the Pennsylvania Constitution, which prohibits cruel punishment, or the Eighth Amendment to the U.S. Constitution, which prohibits cruel and unusual punishment. Please proceed.
Thank you, Your Honor. And first, I'd like to introduce my co-counsel, Quinn Cousins and Samaz Sise, and in the gallery, Pardis Cabrai, Nia Holston, Rupali Rashatoire, and Nikki Grant.
Welcome.
Good morning, and may it please the court. My name is Brett Brody, and I represent appellant Derek Lee, who has been sentenced to die in prison for a felony murder conviction based on his role in a robbery in which he did not take a life or intend to take a life. If Mr. Lee lives to be 76 years old, at which point it will be the year 2064, and he will have been incarcerated for 50 years, even then he will not be able to go in front of the parole board even if the Department of Corrections considers him long since completely rehabilitated. He must die in prison for the unintended consequences of criminal conduct and a killing committed by another person. This must no longer be permitted under the Pennsylvania Constitution. It speaks volumes that the Commonwealth and its amici do not defend life without parole for felony murder on the basis that it is necessary to deter crime, or that it has any greater deterrent effect than life with parole for felony murder would have. The only real dispute they raise is that the Pennsylvania Constitution's provision outlawing cruel punishments must be interpreted identically to the United States Supreme Court's interpretation of the Eighth Amendment's cruel and unusual punishment clause, which they argue would deny Mr. Lee relief.
What do you cite to persuade us that our Pennsylvania Constitution provides broader protection against punishment than the U.S. Constitution?
Thank you for that question. I would cite to the distinct text and the history informing the meaning of the Pennsylvania Constitution as well as the meaning of the federal Constitution. Pennsylvania Constitution's cruel punishments, federal Constitution, cruel and unusual punishments. Starting with the federal Constitution, the term unusual has a distinct substantive meaning within the U.S. Supreme Court's jurisprudence. This was recognized in Harmelin v. Michigan, where it was mentioned that, discussed that unusual meant contrary to long usage, contrary to the common law. This was reiterated in Bucklew versus Presseath in 2019. And just this past summer in the Grants Pass case, unusual meant punishments that had fallen out of usage and that were not recognized as common within the jurisdiction.
Hasn't our court held that those two constitutional provisions are coextensive?
This court has held that in Commonwealth v. Zettelmoyer, Commonwealth v. Baker, Commonwealth v. Batts, but it is made clear, especially in the post-Edmunds holdings, that an Edmunds analysis must be engaged in every time a specific claim is raised under the state constitution. This is the first time that life without parole for felony murder has been in front of this court under an Article 1, Section 13 claim.
Which, counsel, brings me to my particular concern. For us to tread on the Constitution is a significant act. The concern that you're addressing is not so much a constitutional issue, but a statutory issue for which life without parole is applicable under statute 6137 for felony murder. Why should we not restrain from addressing the constitutional issue and require the General Assembly to amend that statute?
This court cannot require the General Assembly to amend the statute without...
I got that.
without striking down an unconstitutional statute, which then could incentivize them to make that particular change. But there is a legal question in front of this court as to whether Mr. Lee's sentence violates Article 1, Section 13. And the assessment for whether it violates Article 1, Section 13 must flow from the Edmunds analysis and the standard that is applied to assess this sentence. Under the Edmunds analysis, we have to go back to the history of the founding, the very framing of Article 1, Section 13's cruel punishment clause, and to refer to the Zettelmoyer, Baker, Batts line of cases. None of those cases address this history. And we have thoroughly briefed and cited ample historical evidence that the founders of the Commonwealth of Pennsylvania viewed cruel punishments as those punishments which were excessive to the need to deter others from committing crime and to reform the person who...
Can I ask you a question on that?
Oh, I'm sorry. I'll be done in just a moment. As I understand your argument, you are not saying that there aren't some cases of felony murder that would be appropriate for a life without parole sentence, but that yours is not, and that the court should have the discretion, therefore we should strike the mandatory part of the statute.
So thank you for that question. We believe there's multiple different ways you can strike Mr. Lee's sentence down, and the way that we think categorically addresses the disproportionality for second-degree murder focuses on the lack of a specific intent to take a life. That lack of a specific intent to take a life is present as a matter of law in all second-degree cases, but we also recognize that this court may issue a ruling that is taking into account the lack of a specific intent to take a life, plus the fact, in this case, that Mr. Lee did not take a life. That's a narrower subset of second-degree cases.
So you're asking us to parse out the mens rea requirement.
But we're asking to focus on the mens rea requirement as the most salient factor that leads to a disproportionality analysis from our perspective.
Back to my
Counsel-
question, excuse me, the argument you're making doesn't discount that there are some felony murder cases that you would acknowledge are appropriate for life without parole, but you don't want the mandatory life without parole to apply to every case. Is that correct?
We're not acknowledging that life without parole is constitutional for any second-degree murder case. We're most specifically...
But you're not arguing that it's not.
We're arguing that in this case, it is not. As to other cases in front of the court may not reach those cases, and the court may leave for another day whether Article 1, Section 13 is unconstitutional with a fact pattern not in front of this
Well,
case.
but I thought the gist of your argument was that based on our ruling in the future, the trial courts would be able to sift through the facts and decide based on the mens rea or lack of mens rea whether or not it's a case suitable for life without parole or just life.
So that's not our argument, but that's a way that the court could resolve this
It's
case.
a good argument, though. Isn't it?
I don't disagree with that. We have a number of arguments that we like. Some we like more than others. Maybe if I can sketch out, I think there's 4 ways. We could probably imagine more, but I think there's 4 ways that Mr. Lee's sentence could be struck down. The mandatory nature of the sentence could be struck down, and that would allow the resentencing court, after a proceeding considering facts and circumstances of the case, Mr. Lee's role in the offense, any mitigating evidence, prosecutorial and victim input, etc., whether to impose life with parole or life without parole.
How is that a sentence under the Pennsylvania Sentencing Code? Life with parole. How would that happen?
We believe that would happen the same way that after Miller v. Alabama, Commonwealth v. Batts engaged in a severability analysis that allowed a sentencing court to impose a life with parole sentence at its discretion when there was no statute commanding when the minimum sentence would be imposed or whether or not there would be some statutorily based minimum.
I thought the sentencing code was designed in such a way that any life sentence resulted in without parole.
It is designed in such a way as it was.
And so then how do we eradicate that aspect of the code?
So I would direct the court to this court's decision in Commonwealth v. Batts, the 2017 version, in which the Commonwealth severed the Section 6137 of the Parole Code that prohibited parole eligibility for those sentenced to life imprisonment if they were younger than 18. It also severed the requirement that a sentencing court peg its minimum to half of the maximum, since there was no half of a life sentence. And then at the discretion of the resentencing court, taking into account relevant legislative statutes that did not directly apply, specifically the 1102.1, which was for cases of first and second degree murder committed by somebody who's younger than 18 that occurred after Miller v. Alabama. The court imposed a minimum sentence after that severability analysis. The court also recognized in those Batts decisions that the legislature could have intervened and created a sentencing scheme.
And they did.
They did, yes, and it was for the cases that where the crime was committed on or after the date of Miller v. Alabama.
Could I stop you just a moment? Justice Wecht got cut off a little bit ago, and I want to give him an
Well, I'm
opportunity to
happy to
finish
let
his
Justice
question.
Donahue finish her line, Chief.
And
I
then-
actually have a different line, so you may pick up my line. So be my
Well,
guest.
thank you both for the lines. Counsel, a moment ago, you had mentioned something consistent with your briefing, about the penological aims of deterrence and rehabilitation. Is the General Assembly not entitled to other objectives in their lawmaking capacity, for example, retribution? And to the extent that that is an impulse that legislators are allowed to pursue, how are we to construe that in terms of this argument?
So we think the historical evidence of the legitimate punishments or purposes of punishment embedded within Article 1, Section 13 were deterrence and rehabilitation. However, if this court were to include what the U.S. Supreme Court has recognized as two other major legitimate interests, retribution and incapacitation, we think it's the same result. Retributive theory, also sometimes called just desert theory in the jurisprudence and the criminology literature, is focused on a proportional punishment for the offense that is at issue. And punishing people for the unintended consequences of their actions, punishing people for felony murder convictions in Pennsylvania with the same punishment as those who have specific intent violates retributive principles as well. We briefed this in the 8th Amendment section of our brief, and it was also touched on by the criminologist amicus curiae brief as well. As for incapacitation, I think that's fairly subsumed or could be under the rehabilitative analysis. If somebody is rehabilitated, by definition, they do not need to be incapacitated in order to protect the public.
Counsel, I tease out a comment you made. Am I to understand your position is that there should be no minimum for felony murder? And if so, many of the amicus briefs shared with us the overwhelming disproportionate contact or those incarcerated based upon the statute as written. Are we not treading again into difficult territory by having disproportionate sentencings, allowing the judges to determine what the maximum or the minimum? What if the minimum were 99 years to life?
So I'm not going to pretend that there's not complicating factors with the remedy. We proposed the severability analysis that this court engaged in as BATS as a way to resolve this case because it's something familiar to the court in its jurisprudence. It is the case that the court would have options if you strike down Mr. Lee's sentence, including retaining jurisdiction in order to seek supplemental briefing on the appropriate remedy consistent with a rule that this court would announce, including putting a ruling on hold to give the General Assembly a time to act, which has been done in other instances. There would be a minimum, and I don't believe there would be a risk that courts of common pleas would not discharge their duty to impose a minimum that matches somebody's individualized culpability. And in fact, in the remedy that we propose, individual culpability would still be relevant in 3 critical phases of the sentencing process. The first would be imposing a minimum for the second-degree murder offense itself. If the legislature were to act in response to a ruling of this court to guide how that minimum would be set, that then would also be taken into account. But the second critical juncture where individual culpability would be assessed would be in imposing an aggregate sentence. Oftentimes, maybe all of the times, I would say most all of the time, when there's a more severe course of criminal conduct, there's multiple charges, multiple convictions. Nothing in the rule that we are seeking would limit or hinder a sentencing court's ability to impose aggregate, consecutive, stacked sentences.
Why don't you share with us the rule you believe we should make?
We believe the rule should be that life without parole for felony murder, where there's no intent to take a life, is disproportionate to the legitimate purposes of punishment and unconstitutional under Article 1, Section 13.
Well, that's different than the juvenile cases, for example. The juvenile cases were a categorical situation. You're basically taking anybody who is guilty of felony murder should not get life without parole. is that a facial challenge? Is that an as-applied challenge? What are you advocating here?
So it's a categorical challenge focusing on the sentencing statutes.
Well, it's a category challenge focusing on the entirety of the universe as the category. That's what you're focusing on.
That's we'll say our maximal position, but we also recognize the court may decide there's a narrower subset.
But your client voluntarily engaged in a violent felony. This isn't the getaway driver situation. Your client voluntarily, with guns, entered a home he shouldn't have entered into, pistol whipped somebody, happened to leave the room, and surprise, you enter a room with you enter a house with a felony to commit a burglary, and somebody dies and gets killed and shot. Is your client the client that you're saying falls into this category that we should say, oh, for all of these people that engage in violent felonies with guns, where you're obviously thinking if you're going to somebody's home with a loaded gun, somebody might die. This is the situation we should say he falls into that category and life without parole is unconstitutional for him.
Yes, we believe that him not having an intent to take a life and not taking a life would allow such a ruling. A lot of the conduct you just described, if somebody did not lose their life, is subject to severe penalties under the law.
But somebody did lose their life.
Without parole. And that's where I agree with Governor Shapiro, that somebody lost their life. Felony murder should permit more serious consequences than simply punishing somebody for the underlying felony. As Governor Shapiro also said, mandating life without parole where there wasn't a specific intent to take a life doesn't further deterrent ends. The U.S. Supreme Court and the Pennsylvania Supreme Court have spoken to the mismatch between deterrence and a crime where there's not premeditation. In 1970, this court stated in Commonwealth X. Frail Myers v. Smith, if added deterrence is the goal, the felony murder rule is not the right approach. In 1982, in Edmond v. Florida, for the U.S. Supreme Court, they recognized for capital punishment to be an effective deterrent, premeditation has to be involved in the murder. So we are not arguing there should not be severe consequences for second-degree murder. Life with parole is a very serious penalty.
You're not agreeing with the governor's amicus brief, it seems. You wouldn't view it as a win, so to speak, here, if you got a ruling that said mandatory life without parole is unconstitutional. You're more ambitious than that in this context, right?
We would definitely consider it a win if Mr. Lee's sentence was struck down and mandatory life without parole is unconstitutional. Absolutely. We agree with much in the governor's brief, not everything in the governor's brief.
But I mean, you don't want the Miller-Batts type approach. In other words, you don't want the individualized inquiry empowering trial judges to decide whether this person gets life without parole and this one doesn't. And I'm not sure why you think you've made a compelling case to go beyond that.
So we think that felony murder, consistent with, say, the U.S. Supreme Court's decisions in Edmond, also Graham v. Florida about non-homicide offenses, which relied on Edmond, their capital penalty jurisprudence dealing with crimes that don't involve a specific intent to take a life. Those were cases that took the penalty off the table altogether. But it is certainly the case that if the standard this court were to find in Article 1, Section 13, permitted that life without parole may be constitutional in some instances for felony murder, then the mandatory nature would have to fall, and sentencing courts would have to make a decision as to whether a particular offense warranted life without parole based on the standard this court would announce to apply Article 1, Section 13.
Quite frankly, I thought that was going to be the gist of this argument.
But it's not. But it's not. Counsel, you keep referring to Batts, and I understand the argument that you're making, but this court had a cushion in Batts. because the legislature had already adopted a sentencing code that dealt with the juveniles in these situations. And if you'll recall, in Batts, we said to the trial courts, and why don't you follow in your sentencing scheme that which the legislature had set up? So Batts was really a stopgap. That's not what you're talking about here at all. I mean, you know, if this court struck down this sentence, the legislature would have to do something. I mean, do you not agree?
I agree, and I think the procedural analog to where this case would actually be Miller v. Alabama. When Miller v. Alabama was issued, the Pennsylvania legislature had not acted. Obviously, that was a U.S. Supreme Court decision, but if there was a decision in the first instance on the constitutionality of the mandatory life without parole sentencing scheme, then that would basically put us back pre-Batts.
Counsel, don't let me lose my place in line here to get to my line of questioning. What is the mens rea for this crime?
The mens rea for this crime is having the intent to engage in the underlying felony.
Okay. And how does that translate into being punished for the death?
Because there's three elements. The mens rea, I just said, the criminal act is participating in the underlying felony, and a death has to occur in the course of that felony.
Does a individual have to have a recklessness mens rea? You see my problem? And I think the District Attorneys Association and others have suggested that what your problem is really with is the crime. I mean, because you're asking us to parse situations in which an individual dies in the midst of the commission of a felony. Your client was not in the getaway car, but this rule applies to the individual who is in the getaway car. This rule would apply to someone who did not know that the other perpetrator had a gun or a weapon. Am I correct?
Correct.
And isn't that what is the gist of your problem? The latter individuals that I described, somebody sitting in a car not knowing that his accomplice had a gun, and that there was even a possibility that someone would die in the context of this commission, is going to go to prison for life without parole. Correct? And isn't that what you're asking trial judges to have the ability to do, to parse that type of conduct?
Yes, we would like trial judges to be able to separate between levels of culpability.
But then that's not the statutory crime.
Yes, and we recognize that problem, which is one of the reasons we focused on the element of this lack of specific intent, because that flows from the statute itself. There are other felony murders.
But that's the problem. The statute presumes that. The statute presumes that there is some mens rea in the commission of the murder. Correct?
Well, the mens rea is imputed from the mens rea.
What is imputed? It's the
malice.
From the underlying felony.
Correct.
Not the murder.
Correct.
And therein lies the problem, correct?
One of the problems. Yes.
So for us to say to trial judges, take a look at what really happened here. Your client, in the examples that I just gave, had a greater culpability than the individual who's sitting in the getaway car without any knowledge of a gun being present in the perpetration of the felony or anything like that. But then we aren't talking about the felony murder rule. We're talking about something else. We're talking about a judge determining what the mens rea is for the actual commission of the murder. And that's not the felony murder rule.
So I'd follow you in what you're describing. If there would be a mens rea attached to the homicide, would essentially be one of what I refer to as an aggravated felony murder statute that other states do have.
But isn't that what you're talking about? Isn't that what you're asking us to direct trial judges to do, assuming we could do that without the legislature stepping in and fixing that problem?
There's different ways we can come to relief. We're asking this court to make a clear recognition, as Governor Shapiro and others have in the briefing in this case, between specific intent murder.
And no intent
Correct.
to commit murder.
Correct. Now, when you mention, is it recklessness for those perhaps who have committed the act that led to a death? It could have been. It also could have been a voluntary manslaughter or an involuntary manslaughter situation. I know real cases, and we can talk about that all day. We also know cases where it's going to be difficult to determine because the jury's not required to prove in some case or to make a finding as to who even committed the murder. If this court were to say there's too great a risk of punishment because mandatory life without parole, too great a risk of excessive punishment, sweeps in so many people whose role in the offense and their criminal intent was such that life without parole would not be justified, I think the court could allow a discretionary sentencing scheme that, like so many other sentencing schemes in Pennsylvania, allows trial courts to impose this based on an assessment of one's culpability and the presentations at a sentencing proceeding without that turning into a type of formal fact-finding which would make it an element to the offense.
Well, interestingly, your client doesn't meet that definition of someone who was not plausibly, did not have an intent. He had a gun, right?
So that I don't think means he had any intent to take a life.
Went into the burglary with a gun, or the robbery, whichever it
And
is.
the U.S. Supreme Court considered that argument in Edmund v. Florida as to whether robberies and certain violent felonies are so inherently dangerous that it should justify, in that case, capital punishment, and it would have a deterrent effect. And they rejected it. And I think that
was capital punishment. That's not. And I thought you didn't want us to look to the United States Supreme Court. I thought you wanted us to look to the Pennsylvania Constitution.
I want you to look at both. And the U.S. Supreme Court can certainly provide guidance and a floor for interpreting the Pennsylvania Constitution. When it comes to this being capital punishment, the analysis of deterrence and one's culpability, I think, still holds for life without parole.
The United States Supreme Court, to my knowledge, has not yet ruled life without parole for felony murder is unconstitutional under the United States Constitution, except for juveniles category.
Correct, but there are other holdings from their
relating to capital punishment.
From their categorical jurisprudence, which includes capital punishment, as well as Graham and Miller, that I think have a lot of
Miller was a
teachings and
juvenile
guidance
case.
that can be very illuminating for this.
I want to just follow up on Justice Donahue's point here. She gave you some facts that let's talk for a second about the getaway driver, which seems to be coming up in every brief that I've read about this. What about the getaway driver? Are you telling me that in Pennsylvania, the district attorneys and juries are convicting mere getaway drivers who had no idea that a violent felony was about to be committed and did not participate, that DAs are charging them with felony murders, juries are convicting them of felony murder and sending this pure innocent getaway driver to life without parole?
There's cases where getaway drivers and lookouts have been sentenced to life without parole, certainly.
And this is a facial challenge, isn't it? Is your challenge a facial challenge?
Our challenge is to
They could be sentenced to life without parole under the current scheme. The getaway driver.
They certainly can be sentenced to life without parole, yes. Our challenge is to Mr. Lee's sentence.
So you're raising an as-applied challenge. You're not raising a facial constitutional challenge.
We're making a categorical analysis, and we understand
Counsel, I'm going to just interrupt for a second. It's in Pennsylvania, we have two types of constitutionality challenges to statutes. They're either facial or they're as applied. Are you raising a facial? Because the law is different on both. Are you raising a facial challenge or an as applied challenge? We analyze the question differently depending on whether it's facial or as applied. Which are you challenging?
We're asking for a distinct analysis this court's never engaged in before. under the state constitution. And we
You-
figured that has to
so
have
you can't tell me whether you're raising a facial or an as-applied challenge.
I think both challenges are fairly encompassed within the questions and the arguments presented.
You're making a categorical challenge. I don't know how that is not a facial challenge.
Okay, so we're making a categorical challenge, but we also understand that if this court believes that life without parole may be constitutionally permissible in certain instances, there is for striking down Mr. Lee's sentence, namely the mandatory nature in which it was imposed.
That would still be facial.
Yeah.
Because we'd be striking the mandatory.
Okay,
Your category is everybody who could be charged with
Right.
Yeah, that's fair.
felony murder.
You're even asking us to consider retroactive application, so it seems clearly facial.
We recognize you do not have to consider retroactive on direct appeal. We think there's reasons to address that sooner than later. The Attorney General's brief said if it is struck down, it should be addressed sooner than later. We also recognize that that raises challenging issues that have not been briefed, supplemental briefing if this sentence is struck down.
But after Montgomery, how can it not be retroactive if we go there?
If we strike down life without parole as unconstitutional, there literally has to be a resentencing for all 1,100 people that are currently serving life without parole sentences in Pennsylvania. Does it not?
Not necessarily. As Montgomery v. Louisiana itself said, the remedy for Miller v. Alabama did not have to be resentencing. It could be making defendants parole eligible. So the legislature could act.
It would be a watershed moment, correct? If we
Correct.
Question I have, excuse me. Following your theory and your request of this court, share with us how that jives with felony 3, where you have a 40-year up to. Are you asking this court, if we strike it down, in essence, someone charged with felony 3 could be hit with a more severe sentence than felony murder? At least that's what I'm gathering from you. I want you to clean that up for me.
When you say felony 3, are you referring to third-degree murder?
Yeah. I apologize. Murder 3.
Quite all right. No, I think second-degree murder would have a more severe penalty. Instead of a 40-year max, it would be a life max. And I think courts are...
Where do we start at the minimum? 40 to life? Since 40 is the top for murder 3? I'm just trying to find out...
40 is the max for murder, right? So 20 would be the minimum under the state law, right? It couldn't be any higher than that. For those who are 17 or 16 and are guilty of second-degree murder, the legislature set the minimum at 30. So I don't think I can tell you that courts thereby should, deviate from that as a categorical nature in setting a minimum. That's what the statutory law is for second-degree murder for those who are younger than 18. The minimum's 30. So we're still talking about very severe penalties. There is a question about what the sentencing court could impose if the legislature has not acted to give it guidance.
It's a big question, because is there a way we can give your client relief here without rewriting the sentencing and parole code? There's a difference between striking things. We can strike things, and then we engage in a severability analysis. But what you're asking for, to me, commands us to write something. And that is something that belongs to the General Assembly. How can we grant relief to your client without rewriting the sentencing and parole codes?
The same way that relief was granted in Commonwealth v. Batts, which was a severability analysis. And courts did have discretion to impose minimums. They were guided by 1102.1, but I know many, many people who were sentenced to less than the 35-year maximum for first-degree murder when they were resentenced because courts
What's your client's minimum?
What do we think it is, or what it should be upon remand?
Yeah, because the legislature hasn't set one up, right? So if we were to strike this, in your view, your client gets resentenced, right? What's the minimum? I mean, we'd be making it up just as much as you'd be making it up here. So why don't you tell us what you think the minimum should be?
Correct. We would advocate for 25 years, and the court would probably not impose less than 30, would be my guess.
But you're really arguing for the back end, not the front end. I mean, we have a minimum maximum statute here. You're just basically saying life without parole, without a possibility of parole, is unconstitutional. Therefore, every single person that's sentenced to life without parole in Pennsylvania gets a hearing to determine whether or not they've served enough time. What are you asking us to fashion is really the question I think you're hearing that's being weaved throughout this
Well,
particular
the problem is life without parole. You can't, under the parole code, you aren't considered for parole until you've done your minimum.
Well,
And there's no minimum.
I thought you were arguing, at least in part, for us to just declare it unconstitutional, and then we could give the legislature 90 days or whatever to redraft it.
I think that would be prudent, especially given the conversation today and all the challenges that there would be.
Counsel, how could they redraft the sentencing code without redrafting the crime? You understand my problem. I mean, every time we get down to this question about, well, what should your client's sentence be? The answer is it would depend on his mens rea. Would it not? I mean, to suggest that something that our ruling would apply retroactively would somehow imply a one-size-fits-all sentence. And is that really true, given what we're dealing with the felony murder rule as it currently exists?
The first question you raised, how could the legislature engage in a remedy here? They can amend the parole code. And they can amend the parole code in different ways. They have authority to do that.
But how would a judge decide what the appropriate sentence is if there is no context in which to determine what the defendant's mens rea is vis-a-vis the actual crime for which he or she is being punished, i.e. the murder?
So I think the court could still take into account a number of factors even without an additional element of the mens rea. In other sentencing proceedings, people are convicted of one or more offenses that have their mens rea and actus rea, and the court has a range of punishments that are within its discretion to impose. We're simply arguing that life without parole, the without parole, must be struck down. Life with parole.
That's why I made the suggestion earlier. What you're essentially asking us to do is strike down as a facial challenge life without parole, which would require a resentencing for every single inmate right now in Pennsylvania that's serving life without parole. Because what you're really asking us to do is not engage in a factual analysis. It's to give it to the sentencing judge some discretion to hear mitigation, to hear the facts and circumstances of the case, to see what participation, if any, that this particular individual who's serving life without parole participated in the actual case itself. In other words, the getaway driver, as Justice Brofson just mentioned, the person who goes in with a gun, but it's not necessarily the person that fires the fatal bullet. Correct?
That could be one way to respond. The legislature could amend the parole code and say anybody that has been in X number of years is parole eligible. They could also say somebody who has been convicted of second-degree murder and it was this underlying felony, they set this particular year number for a minimum. Different underlying felony, they set a different year for minimum eligibility. They would have options in that regard.
Hasn't the legislature been lobbied to rewrite this statute?
They have, and they have not taken that up. I also...
Well, in fairness, they have had hearings. There is a bill. I think it's in the House. It's not like not like they've rejected it. It's under consideration.
I mean, there's been a hearing in the House Judiciary Committee, but for years and years and years, they have not had any full votes. They have not passed, and this court has to roll, of course, on the constitutional questions in front of it without speculating if there's a violation here. The legislature may solve it in the future. But as to the concerns, though, about if any rule is issued, if it would necessarily be retroactive, would that unleash the need for 1,000 resentencing proceedings in Pennsylvania? I do want to make clear that if that is the consequence, if those sorts of, to use the words of this court from Commonwealth v. Wolf in discussing the what happened after the U.S. Supreme Court's Alene ruling, if these sorts of unavoidable and wide-scale consequences are required, then that is necessary to enforce constitutional rights. Pennsylvania has had a recent, resounding unequivocal success with resentencing over 500 former juvenile lifers. One study, it's been cited in many of the briefs, found 1% recidivism rate. That's just unheard of when it comes to other criminal offenses.
Counsel, again, you keep going back to the juvenile lifers. These are not juveniles we're talking about. Let's again, I want to go back to this. Let's assume you're right. Let's assume we believe that facially it's unconstitutional. The remedy, you concede, is not that all these people get out of prison, right? You would suggest there has to be some form of resentencing.
Unless the legislature amends the parole code, yes.
Okay, so, but in the resentencing, I'm trying to understand, let's assume there's no action by the General Assembly, because usually when we ask them to, they take their time. What can we do as a court to give relief? Because I asked you about, are we to say, as a matter of constitutional law, because in order to be eligible for parole, you need to meet your minimum, right?
Correct.
Okay, so as a matter of constitutional law, does this court have the power to say from here on out until the General Assembly amends the statute, felony murder has a mandatory minimum of 25 years to life? Do we have authority to do that?
Under your power to create rules to enforce constitutional rights, I believe you would have the authority, but I'm not familiar with it being exercised in that particular way within Pennsylvania, but I'm also not aware of any case where this court has used Article 1, Section 13 at all, let alone to strike down a sentence and to create a remedy for that. But I think you have the power to create constitutional rules.
To specify a minimum number of years. For us to sit here and, I hate to use the L word, but to basically legislate a minimum term.
If it's now you're just asking me what the court has the power to do.
Well, I'm trying to figure out what we can do to give your client relief if your client wins.
Right. I think you could do that.
You think we could also say, strike, keep life, because it's two statutes, it's life, and we could also amend the parole code to basically say, because right now the parole code says you're eligible at your minimum and life does not have a minimum, we could blue line and add language there that says, unless you're serving a life sentence for felony murder, in which case you're immediately eligible for a parole hearing. We could add that language to the parole code too.
I don't think you could add that language, but for a different reason. Because that sort of immediate eligibility for everybody would not be preserving as much of the legislative statute's intent in order to remedy the constitutional violation. That would be going way beyond.
So then, unless there's a third option, our only option is for this court to set a mandatory minimum for felony murder.
That is an option.
Well, okay, so that's an option that you said was good. Amending the parole code is not an option. What's the third option?
Wait.
I gave you two options. One was for this court to legislate a mandatory minimum. You said we could do that.
You could create a rule to enforce a constitutional right. I would not use the L word.
That we could create.
I would not use the R word. I don't think we can do a rule.
We could create a mandatory minimum. I would legislate, rule, whatever. But you think we can.
Some other word. I don't think you ever have, but I think it's possible.
We can't, however, according to you, rewrite the parole code to say people serving life for felony murder are eligible for parole. We can't do that.
I think that you would have to attach a number of years in order to preserve as much of the legislature's intent as is constitutional.
But that's more jiggering with the statute, right?
It's no different from the first example as to what a minimum would be before somebody's parole eligible in order to comply with what would be a rule under constitutional ruling under Article 1, Section 13.
Now, other than those two, is there a third option for us to get relief, give you relief?
Resentencing consistent with the court's decision in Batts for Mr. Lee.
But where do we get the
I thought you
number?
were arguing for us to find it unconstitutional, in which event we would send it back to we would hold the ruling for a certain number of days, the effective date, until the legislature acted, or we would simply declare it constitutional and let the unconstitutional and let the chips fall where they may. I don't see any options for us to rewrite something the legislature has written. We don't do that.
I agree that you don't do that. That's why we did not advocate for that as a question of the court's constitutional powers when engaging in the establishment of constitutional
No, but
rights.
That's the problem. That's the problem, counsel, because magic doesn't like if we strike it down and send it back. If your argument isn't that they're all instantly eligible for parole, the trial courts need to know what to do. If there's no minimum in the parole, I mean, that's where do we make up a number? That's I thought what Justice Brobson was getting at it.
Right. No, so I follow. So I think that what Chief Justice Todd just said about our position, that it can be struck down, you can maintain jurisdiction, even request supplemental briefing, and give the legislature time to act, and the legislature could then provide that guidance in that minimum.
And if they don't?
And if they don't, then I believe we're back to Bat's severability, unless this court were to use a power under Article 1, Section 13 that has not been used to state that life without parole for felony murder is unconstitutional, and in order to remedy that, individuals sentenced to life without parole for felony murder must become parole eligible after 25, 30
Where does
years.
that come from? That's the question, because we had something in Bats. We had something. That's what I'm getting at. Where do we get that number?
Where do we draw the line?
Right. The most, I think, proximate sentencing statute is the sentence for life without parole for felony murder for those who are younger than 18. That's the most proximate to this case. There's also different underlying felonies that are involved that often people are convicted
So you're saying is we should take the legislature's intent to extend grace to juveniles and apply it to everybody.
That was not what we said. This was that asking where to find a minimum. It makes sense to look at the only other instance where second-degree murder has a punishment attached to it in the statutory code.
All right, are there other questions for Mr. Grote? I think we understand your position. Thank you, sir.
Thank you.
We'll hear from Mr. McCarthy for the Commonwealth.
Chief Justice Todd, members of the court, may it please the court, Kevin McCarthy, Assistant District Attorney, Allegheny County, on behalf of the Commonwealth. Chief Justice Todd, Justice Donahue, you have demonstrated my own problem in addressing the arguments of counsel. I can't seem to find exactly where appellant is going and what he wants. As I said in my brief, this argument is really a challenge to the felony murder doctrine, period. They don't like the sentence, which is unique to felony murder. And instead, they want to say that the sentence is unconstitutional as opposed to the crime is unconstitutional, or rather the definition.
That's the point. Punishments can't be cruel, so that's what we're asked to decide. I mean, they're saying mandatory life without parole violates the cruel punishments. Why isn't that justiciable?
Well, I do believe it is. I'm just saying my consternation and struggles with trying to respond to arguments. It seems as though I'm grabbing in a phantom.
Well, but the arguments are incongruent. I mean, if there's a problem with the manner in which someone is punished, which has nothing to do with that individual's actual culpability for the act for which you're being punished, that would make the sentence for that unconstitutional. I mean, where's the incongruity?
I would agree with that. But of course, as this members of the court have pointed out this morning, is it a facial challenge or is it a as-applied challenge?
I think we've determined it's a facial challenge.
I thought it was too.
Oh.
And I'm prepared to respond to that as applied, it is not unconstitutional. Appellant has many sympathies and mitigating factors on his side. The Commonwealth has history and this court's precedent on its side. Felony murder doctrine was adopted by the Pennsylvania legislature in 1794, 4 years after it enacted ratified the first Constitution, including the prohibition against cruel punishments.
But nobody, sorry to belabor this, Mr. McCarthy, but I shouldn't say nobody. For present purposes, we don't need to question the felony murder doctrine. The question is, I thought, whether mandatory life without parole on felony murder is constitutional. And so that seems to me the issue, or at least an issue here. Without troubling the felony murder doctrine, the question of whether the judge were being required upon that verdict to sentence to life without parole.
Well, that's my point, Your Honor. The felony murder the sentence for felony murder was mandatory since its inception. And in 1794, it was death. And that was amended in 1925 to be either life or death, and amended yet again in 1974 just to be life without parole. Mandatory. And this court has repeatedly found that that was an appropriate exercise by the legislature to punish someone who is responsible, who has the mens rea to engage in the underlying violent felony.
Now there's the problem, right there. That's the mens rea, to engage in the underlying felony. That is not what these defendants are being punished for. They're being punished for a murder. And therein lies the issue with whether or not that is cruel, to punish someone for an act where no intent or recklessness or any other level of mens rea has been established. That's the argument for why it is cruel.
Well,
don't we have a general rule in this Commonwealth that in order to punish someone, there has to be a mens rea?
yes.
Okay, and we don't have a mens rea for the act for which these defendants are being punished.
Well, it has been the law of Pennsylvania. The legislature imposed, or General Assembly imposed it again all along, that you are being punished for participating in a violent crime which was foreseeable.
There you go. I mean, what about the infamous now getaway driver? What about the?
I got him right here. But I got him right here.
This is a facial challenge. Let's talk about somebody who is not this defendant. Let's talk about someone to which this crime attaches, which is the getaway driver.
The legislature, or the General Assembly, recognized that violent felonies, participation in a violent felony, is dangerous conduct, that innocent victims' lives are lost, and that we must deter that kind of conduct, and there is a severe penalty applied. And as
Justice Donahue said, there is a punishment for the
Felony.
for which they're partaking,
Yes.
not for the murder. So you're asking us to double dip punishment.
the General Assembly has. It's not that it's double dipping, although they are often sentenced for the underlying felony too. Yeah, but they're sentenced for life without parole for agreeing to commit the crime, participating.
It's accessory liability.
It is absolutely accomplice liability, which is what we noted in our brief. Accomplice liability, each and every member who participates is responsible to the same degree and can be punished to the same degree. And that's
For the crime in which they intended to participate,
arguably
correct? Okay, well then we're back to,
we impute, and that's this court's language, that we impute to the least culpable of the Confederates
In
that,
theory, these are naturally foreseeable consequences.
yes, Your Honor.
The problem, so I think the discussion though is the question is, can this argument, if we adopt it, will the felony murder charge even survive? Because if we say in order for you to be held accountable for the crime of felony murder constitutionally, you had to have some sort of an intent to kill, then you wouldn't need felony murder.
Correct.
You'd have manslaughter or any other
degree
form of homicide because there was an actual intent or recklessness. There's another charge. But if we go along the lines and start looking at whether it's cruel and unusual because there was no intent to kill, then that destroys felony murder all the way.
But that's the argument, isn't it? That's the argument of the appellant in this case. I mean, that's why there's a facial challenge. It goes to the fact that this is someone who did not kill and did not intend to kill. I don't know how you wrap that in a different package other than you are attacking the definition of the crime itself. And particularly when we start talking about individualized sentencing for individuals in this circumstance. I don't know how you do that without looking at the mens rea for the commission of the act for which he or she is going to be punished, which is the murder. I mean, that's why I think in part and parcel of this challenge that is sitting before us is how you deal with the definition of this crime in terms of the punishment that's being doled out.
I've thought throughout this whole process, we're always talking about individualized assessment and personal responsibility. And that's always a question of sentencing.
Correct.
So if the Commonwealth has established the elements of the offense as defined by the General Assembly, then we've proven the crime. Now what shall his sentence be? And in this case, the legislature has decided that the deterrent effect of life without parole to people who are engaging in violent conduct, to deter them, because this is a natural and common outcome from home invasion involving robbery and rape. So that's exactly what the legislature was punishing, and why it is a heightened and very, very heightened, because it's without the possibility of parole. But of course, that doesn't end the question, because the sympathetic, the true wheelman, and I have him right here.
Wheelman, I like that. That's better than getaway driver.
Better than the getaway driver.
Right.
Those mitigating factors are going to be presented to, instead of the parole board, the governor's pardons board. Our Constitution provides for executive
And how
clemency.
often does that happen?
Well, it's happened more recently than before, as the briefs.
But that's a vagrancy of the administration, is it not?
It is not so much a vagrancy. Yes, I'll agree with that statement. There were several administrations where they had almost none. But that hasn't been the case in the last two administrations.
But that's not how you deal with a constitutional challenge. And I understand the problem here. I think you can see the struggle involved. But it doesn't change the basic dynamic here, which is individuals are being punished for a crime for which no level of mens rea has been established, and which is truly contrary to anything that I can count as fair in a sentencing scheme.
Well, you would say that imputing it is the same as demonstrating a mens rea.
Correct. And that's what this court has said time and again.
Well, that's the mens rea on accomplice liability theory, generally.
Right, but
Yeah.
specifically as to second-degree murder. It's in my brief.
Right. But one thing I didn't understand that you said a moment ago is that you seemed to indicate you were calling for individualized assessment. And that seems to be the opposite of a categorical sentence for a second-degree murder conviction. So why wouldn't a determination that that life without parole is still available, but it can't be mandatory, but must be the product of an individualized determination, putting aside the administrative problems of the minimum that we didn't get to with you yet, but putting that aside for a moment, why wouldn't that resolve the matter? Since you called for, I thought a moment ago, you called for an individualized adjudication.
I didn't call for it, Your Honor. I agreed with
Yeah.
Justice
I-
Donoghue that
I-
it's the purpose of sentencing.
The purpose
Yes.
of sentencing,
But-
right?
But it doesn't happen. That's my point. But it doesn't happen in these cases, right? Once there's the verdict, it isn't individualized. That's the point.
Well, as a constitutional matter, we have ratified and placed in our Constitution the power of the governor of executive clemency, which supplements, doesn't replace, but supplements individualized sentencing.
But that's not, again, that's not an, look, it may be constitutional, end of story, But if it's unconstitutional, it's not an answer to say the governor can pardon. You don't seriously maintain
No,
that.
I don't do that. I do not mean to suggest that simply because that exists, the statute must be unconstitutional because it doesn't include it within the sentencing. The fact that it stands separately ancillary too.
Counsel, let me ask you a question. You've been at this for a long time. Just put on another hat for a moment. If this court were to strike down this sentence as unconstitutional, what would your suggestion be for the court's option in terms of a remedy? Do we do nothing and say we're going to give the legislature 6 months to devise another paradigm for these situations, or what would you see as a plausible outcome of that kind of ruling, and without any prejudice to the fact that I know you disagree with it?
Yeah, I believe that, as has been mentioned by several of your honors, you should not be engaging in the kind of negotiation that we could do if we were the Judiciary Committee of the Senate and barter as to what the minimum should be. I think it would have to be what you just suggested. I think that's the only remedy that's available to this court at this time, is if you find it unconstitutional, then your honor's correct. It has retroactive application and everyone has to be resentenced. And what's the minimum? What we're going to resentence them to what? We're only saying they're eligible for parole, but when? That's a legislative determination. And as your honor wrote in Hairston, this court defers to the General Assembly on these kinds of matters.
And what would be?
We have done that. It's actually, when we have declared, for instance, the Megan's Law to be unconstitutional and given the legislature a period of time to remedy it, they do it. They know how to do it.
Yes, they have. They have.
What if they don't? What's the? I'm not as optimistic as the chief is. What happens if the General Assembly can't reach some kind of bipartisan agreement and get it through two houses? There's not a lot of legislative days available over the next 6 months or 3 months, however it is. I suppose the governor could call him back in for a special session. I don't know, but let's assume at the end of the day it doesn't happen. What power do we have?
Well,
strike the statute then.
I imagine
Which
your
would
honors
be
would,
catastrophic.
which then puts it
event for the
truly
legislature.
puts the pressure on them to address the problem. I see that as a possible outcome. But to your point that you just made, they have an amicus brief filed by the governor of Pennsylvania supporting their position. I find it hard to believe that if this were put back in the legislature and the governor were to take the reins in this, it can't be resolved. I could easily see.
I don't think you're from Pittsburgh, right?
Yeah, I'm not in Harrisburg.
I'm from Harrisburg.
Fair. But I think it's the easiest legislative fix, if the General Assembly so desired, would be to amend the jurisdiction of the parole board to give jurisdiction over persons serving second-degree murder convictions, that they would be eligible at a term of, pick your number, 25, 40, what have you. But that, again, is a matter for the legislature.
It's almost like the Megan's Law registry changes that happened recently, is the idea that if you've been on the register for so many years, you can petition to come off of it.
Yeah.
That seems to be like the easiest fix. If you've been serving life without parole for X number of years, you're parole eligible, and that wouldn't necessarily require resentencing. It would seem to be a great legislative fix. I just don't know how we could come up with a number.
I don't believe you can, but I think it is the best legislative fix because that provides what I've already mentioned before, individualized assessment. If you have those sympathetic mitigating factors to say, I should not spend the rest of my life in prison.
Or aggravating factors.
Or aggravating factors as
You get a
presented by the
recidivist,
Commonwealth.
You want to treat a recidivist completely different than you want to treat a guy that comes out of the box and gets at 18 felony murder, which is his first conviction. All this does is really allow individualized sentencing, as you're talking about. It allows resentencing for the trial judge to take a look at the individual, his or her participation in the actual underlying crime, as well as their prior history, or lack thereof.
I think you said that the trial judge. I meant the parole board.
Parole board.
If you were to strike down the statute and everyone needs to be resentenced, then yes. And as you pointed out yourself, Justice McCaffrey, We're not talking about just going in and having a sentencing conference. We're talking about having mini trials. We're going to present all the evidence, both mitigating and aggravating factors, et cetera, to prove that this is not just the wheelman. This is someone who engaged in violent conduct as a part of the corrupt
But
conspiracy.
that would go to their mens rea. But
Correct.
that would go to the mens rea. I mean, we keep getting back to what this statute, the felony murder statute, does not require. And that's what it does not require. That determination of what the defendant intended vis-a-vis the commission of the murder.
Well,
Or was it recklessness? I mean, there are and you and I agree that, I mean, generally speaking, if there is no designated mens rea in a crime, we at least apply a recklessness standard. At
Right,
least.
that's the fallback.
At least. It's the fallback. At least. That doesn't even happen here. That doesn't even happen here. So, I mean, this notion of going back for individualized sentencing, from my perspective, you can call it mitigating circumstances or aggravating circumstances. From my point of view, consistent with our sentencing standards, you have to determine what the defendant had in mind vis-a-vis the commission of that murder.
I agree with you, Your Honor, to the extent that that goes to finding whether they're guilty of the crime.
Counsel, do I understand that you are against a retroactive application? Should we find it unconstitutional because it requires judges to work?
No, no, Your Honor, no. That is not my point.
Boy, that's a loaded question.
That is not my point, Your Honor.
As a trial judge, I think that's our job. I've never heard a judge campaign for the job by saying, I don't want to take a case.
I agree with that point.
Might
My
require
point-
the legislators to work.
Yes.
Right? Might require
yes.
them to work.
Mr. McCarthy, to that point, I think it's intriguing. So you've got the front-end sentencing. I'm a little concerned about the idea of having a whole slew of people resentenced. I'm intrigued by the idea of saying that the parole code has to be remedied some way, in the sense that certain number of these people who are serving or have served a minimum time, sort of how the legislature's handled SORNA, are eligible to be considered for parole. What if we gave the legislature, again, assuming the appellant wins here, what if we gave the legislature a specific time to figure out, if it can, what that would look like in terms of the number of years you would have had to have been serving this sentence before you're eligible? And if they don't, we just say everybody who's serving is eligible, and we put it all on the parole board.
Yeah, but you can't do that, because somebody could have been convicted 5 years ago for felony murder, and if we're going to start it, I mean,
Right, but that's the stick. That's the stick to the General Assembly, and that's the stick to the parole board, is to say you guys legislate and figure out a certain number of years, and if you don't, constitutionally, the only remedy we can give is everybody has to get it. That's now they'll deny the 5 year, or they'll deny the 10 year, or something like that, but then it's on the parole board to figure it all out. How's that? Isn't that better than sending everybody back for a resentencing?
Yes. Yes, it is. And to your point, Justice Doherty, having resentencing hearings, my point was that resentencing hearings are not simply conferences and agreeing and discussing what the sentence should be, as in after there's just been a trial and all the evidence has been heard. We're talking about cases that have been sitting for 20 or 30 or 40 years. We're going to go in front of judges who've never heard of this defendant or know anything about it. And that puts...
But that happens every day.
Yeah,
That we have people come before us that we don't know who they are. When I was a trial judge, I never knew the defendants.
But we presented the case to you directly. My point is, these are judges who are now come to the case fresh.
You can still present the case file, because individualized sentencing require individualized considerations. The parole board only takes a look at the adjustment while somebody's in prison and whether or not the parole board thinks he or she should be paroled. Individualized sentencing is required in individualized resentencing hearing, where you can take a look at the factors we just talked about. A, their participation or lack thereof in the crime, their history. Justice Doherty and I and Justice Weck were all trial judges. We sentenced individuals based upon who they were, based upon a lot of other considerations, mitigation factors and aggravating factors. Isn't that a more appropriate sentence if we were to strike down this as unconstitutional?
Yes, but that's exactly what the pardons board does. They don't just look at sentencing, how they're adjusting.
We're not talking about pardons.
That would be based upon the politics, not the fairness aspect.
Could we go back to amending the parole code if that were the option that if we sent it to the legislature, gave them so many days to fix this, and that was the option they chose, what would exactly have to be amended? Just the years of sentence to be served before you're eligible
Well,
for
the way the
parole? Is there
statute's
more
writ-
than that?
I think it's probably just that. It's the jurisdiction of the parole board. The way it's phrased is that they have no jurisdiction over anyone serving a sentence of life without parole. So presumably the new statute would read that they have jurisdiction over those serving life without parole because of a sentence of second-degree murder, which then gets into all of the specifics as to the element, not just the elements, the way the crime occurred and mitigating and aggravating factors. And so while the parole board generally does not apply that, I would argue that it should. That it's not just how they're adjusting in prison, but to the extent that they were less culpable in the underlying crime.
But that's not what they do. I mean, that's not what they do. They look at the course of the defendant in prison.
No, that's part of what they do, though. They have, sometimes the victims come back and testify to remind the parole board of how devastating the crime was.
I was going to say, Your Honor, in every case of a homicide coming before the parole board, my office gets a letter asked to put up any additional information. We get the record. We send them everything we think which is relevant to show that this is an aggravating case and they do not deserve any clemency at this time. On occasion, we've even gone and appeared before the board and testified. You're right, though. The Crimes Victims Act provides that the victim and victim's family have a right to speak to the board. So it has been broadened in that respect. I can't say that it's as broad as if we had a sentencing before a trial judge, but it has been broadened to some degree.
And it does, what else is it dependent on? I mean, if we amended the parole code, then what? Somebody's been in prison for 20 years for a felony murder.
Well, it's
Then
their
what?
opportunity, and I thought that's all they were arguing for, that it's cruel that they not have the opportunity to go before the parole board. Life without the opportunity or possibility of parole. They're given the opportunity, and we've done that with the juveniles as well.
The cruelty aspect is the lack of hope. I mean, there's literally zero opportunity regardless of how they've rehabilitated themselves over the course of their terms of incarceration. I think that's the gist of the argument.
Right.
We're not suggesting
There
here
should be the opportunity.
somebody
That
who's a
creates-
long-time recidivist who has a poor adjustment to prison situations ever get paroled.
Yeah, there are some who served long periods of incarceration and long periods in solitary confinement because they were so dangerous to the rest of the
Deservedly so.
population. Yes.
Are there other questions for Mr. McCarthy? I think we've got it. Thank you so much.
Thank you.
Thank you, Your Honors.
Appreciate it.
appellant brought class action litigation under the Unfair Trade Practices and Consumer Protection Law, alleging that retailers engaged in unfair trade practices by charging sales tax for cloth masks that they allegedly knew or should have known were non-taxable. We granted allowance of appeal to consider whether the unfair or deceptive collection of sales tax occurs in the conduct of any trade or commerce as required in order for claims to be brought under the law. Please proceed.
Thank you, Justice Todd. May it please the court. My name is Corey Woods. I'm here today with Stephanie Moore and Jessica Liu, co-counsel. Just want to introduce them and additional co-counsel in the gallery. I represent Daniel Garcia, who is the consumer plaintiff appellant, among other titles here today. Justice Todd, Chief Justice Todd identified the question: does the deceptive miscollection of sums that are identified as sales tax occur in a merchant's conduct of its trade and commerce? Our position is that it does, and that the Superior Court erred in holding that there's somehow an exception for conducting one's trade and commerce in accordance with applicable law. So let's start where statutory interpretation should start, with the text of the statute. Section 3 of the UTP CPL, or UTPA refers to...
I don't think anybody calls it that.
Say it again.
UTPA refers to unfair or deceptive trade practices in the conduct of any trade or commerce. It then, Section 2, identifies both the words trade and commerce as essentially advertising goods, selling goods and services, distributing goods and services. It then curiously mentions also any other trade and commerce that affects citizens of the Commonwealth of Pennsylvania, which is kind of an Ouroboros if you keep applying the definitions to trade and commerce to the definitions of trade and commerce within the definition. It's a confusing bit. But Section 3, again, it identifies in the conduct of trade and commerce, and then it exempts publishers of advertisements, whether it's on television, radio, publishing. Our position is simple. In the conduct of trade and commerce includes everything that a merchant does in its overall mission to engage in mercantile activity.
Including regulatory compliance?
Including regulatory compliance, comporting its conduct to the applicable law.
And collecting funds as taxes that don't serve to benefit the merchant?
Well, and that's interesting, because this court in Gregg, and I know Your Honor didn't join Gregg, but some did, and it's precedent now, said we're not talking about intent. We're talking about imposing a burden on merchants to ensure that consumers are not deceived with respect to mercantile transactions.
The focus is on the consumer, not on the merchant or where the money goes.
Precisely. This isn't the Punish Unscrupulous Merchants Act, it's the Protect Consumers Act. Interestingly, it comes around the same time as strict product liability, which does a similar thing for dangerous products. If we talk about tincture, we'll be here until well into the evening. But it is part of this time in the legislature when we're saying, hey, we are working on creating the greatest consumer economy in the world. An average consumer but the average consumer shouldn't be forced to figure out whether they're being cheated or deceived in some way. That's up to the merchant. They get to do that.
How were they cheated or deceived? Their receipts indicated they were being charged a sales tax.
The receipts indicated that they were being charged sales tax. They didn't owe sales tax.
I understand, but there's a remedy for that. You're acting like that doesn't happen. That happens all the time across the Commonwealth of Pennsylvania, and there's a remedy for it, and you go to the state and you get a refund. And I sort of disagree with your concept that it's difficult to get a refund. It's not that, particularly on a sales tax item, that this isn't a convoluted sale. And your point is it's very simple, right? So to file for the sales tax refund should have been very easy.
So I want to answer in two ways. First of all, whether or not it's procedurally easy is one question.
Well, I thought you wrote in your brief somewhere that it was procedurally hard.
Well, it's procedurally hard in comparison to the 7 cents that you're going to get on the dollar. But that's one answer. The second answer is this, and we cited the case.
So you should be entitled to more than the tax you pay. That would make it easier.
No, my point is that if we're going to say that something is an adequate remedy, the costs of pursuing it should not be greater than the benefit.
Even if it's the government's fault and not the retailer's fault.
Well, it is the retailer's fault because the retailer has deceived the consumer into thinking that they owe something.
And this is gets us right to the point that I'm struggling with your argument. The retailer is collecting the tax on behalf of the Commonwealth. The retailer is serving as the retailer doesn't want to tax your client. The retailer would rather not do that. The retailer is forced to do it because they're acting on behalf of the Commonwealth and collecting that tax, because the Commonwealth can't have kiosks outside of retail sales to say, oh, hey, did you pay the sales tax on that? Let me collect it. So what you're basically punishing the agent for acting for the principal.
No. So first of all, I think it's something of a weak argument that's been made here. And it's gone a little unexamined that merchants are, in a literal sense, agents of the Commonwealth. The cases that they cite for that, there's two of them. One of them is the Pintech case. That's not dealing with a merchant. That's dealing with an actual taxing authority. So that has nothing to do with whether merchants are agents. The other case is the Gray case, and actually the Schaefer case that's cited within the Gray case. And that is referring to, that's in the context of a consumer that's trying to get a refund of sales tax directly from the merchant. Nothing to do with what we're talking about here.
Well, what's the remedy if the merchant doesn't collect the sales tax? I mean, who's going to come after him? I mean, I'm exploring the converse of your argument. You're saying they're not really an agent for the Commonwealth. What if the merchant doesn't collect the sales tax? What's going to happen?
So if the merchant does not collect sales tax that the consumer is not obligated to pay, nothing happens.
Well, no, if they are obligated to pay, because there seems to be an argument here that the government gave some conflict. Surprise, surprise. The government gave conflicting advice on whether or not these particular items were subject to sales tax or exempt because of the COVID crisis.
So let me push back on it. That's not exactly true. There are regulations, and I know this court's recent cases have said, maybe we should give a little more deference to folks.
I don't know that that's going to be relevant to our analysis, but I think I want to answer my question first. If the merchant doesn't collect the sales tax, what's the remedy?
If the merchant does not collect sales tax that is due, then they have problems with revenue. Yep. That's absolutely true. But here's the thing, and I want to get to this because this is kind of the answer to both your question, Justice McCaffrey, and your question, Justice Robson. I don't mean to point, I'm gesticulating. In the Pecular case that we've cited in the brief, we've heard this song before. We're regulated over here. It's very complex. It's hard to run a business. The UTP CPL is another layer. It puts us in a double bind. In Pecular, the Superior Court, Commonwealth Court, and this court have said in different contexts all over the board, we don't care. The UTP CPL is focused on the deception to consumers, whatever the other regulations say. So that's in the context of insurance. By the way, that's the same counsel who argued Pecular, and said no, insurance is subject to the UTP CPL, even though it's got a boatload of regulation from the state, including a specific remedy about unfair trade practices in insurance. This court said it in the context of purchasing housing in Eldrikin versus Gaster back in the 70s. It said it in Commonwealth versus Monumental Properties about rental housing. And in Pecular, they go over these other contexts: banking, investment, car financing, and public insurance adjusters. So the idea that, oh no, businesses are in a double bind, and so we should shift all the costs of that double bind and the cost of compliance with the law to consumers at a couple cents a clip and they'll never know.
But I understand that point, but in any of those cases, was the defendant acting as an agent for the state as it was here?
So, well, first of all, I think if you look at the insurance industry, there is some authority, and I'd be happy to file a letter brief if it's helpful, that it's so heavily regulated that it's on the order of a government actor. I think.
Oh, yeah, you don't want to go there.
I know.
No,
It gets very
That's not
Byzantine.
true. There's a highly regulated industry, just like the medical profession, just like any licensed entity. But to argue that an insurance company is an arm of the state, I don't think you're going to get there, or that they're acting on behalf of the state. Maybe the MCare fund would be doing that, but not a private insurer.
There's no piece of their action in those contexts going to the state, whereas here it's a different animal, isn't it? This is a piece that's going to the state, a miscollection of that piece.
So first of all, the allegations in this case, we haven't had a deposition. We haven't exchanged any documents. We don't know what they did. They might have put it in their pocket. We have absolutely no idea. And if they had brought up, if they went to discovery and they showed, that's a different argument. But
did you plead that?
We pled that it was deceptive conduct. We didn't plead because we don't know what they did. How would we? They've said in briefs, we've never seen any evidence of it, oh, we just forwarded it to the state. It's fine. But look, whether they give it to the state or not is a separate question from whether it is legally required or not. And that's the question upon which are the consumers deceived or not.
Well, but that goes to the last question I said. The General Assembly has created a remedy for people who are charged a sales tax, who believe it was wrongfully collected, and you go to the Department of Revenue and you get it back. You don't sue the person that collected it and passed it on to the Department of Revenue to get it back. Why is that remedy inadequate? It's been the remedy forever. I mean, this court has seen, and the Commonwealth Court sees on a fairly regular basis, refund claims for refunds of even sales taxes that weren't appropriately collected. Why do we need this extra remedy when all your representative client had to do was click a form with the Department of Revenue, attach the receipt, and say, I need 7 cents back?
So I think that's a legislative question, Justice Probst.
Well, they answered it. They said you submit a refund to the Department of Revenue.
Well,
how would the consumer necessarily know that he has been overcharged or that he, was inappropriately charged sales tax? How would he know that?
Precisely. And that's when I want to dovetail into Greg, right? We're going to create the most powerful consumer economy in the history of the world. And the way we're going to do that is we're going to essentially change the relationship of vendor and customer. And we're going to say that, Justice Wacht, as you said in Greg, it is on the vendor to make sure that the consumer is not deceived in the transaction. And I think that's true no matter whether we're talking about the price of the item, which is really what we're talking about here, because again, we don't know where this money went. But look, let's get back to the government agent issue. First of all, actual government agents are not subject to the UTP-CPL. I think I added an extra P in there. Justice Todd authored the Meyer case, got a majority in that case, and it said the legislature has defined person in the statute not to include government agents. Agencies, at least. In that case, a political subdivision agency, a community college in Beaver County.
Well, these particular merchants aren't government agents. They're acting as trustees for the government. They're taking the tax in trust and then giving it over to the government. And I think the distinction, and by the way, if I were you, I think you did so brilliantly by quoting Justice Wacht out of the box. But my point is that in Greg Ameriprise, my understanding is that Justice Wacht's opinion really talked about a profit motive on behalf of Ameriprise, and that's where the conduct that's likely to be deceptive comes in. What's the profit motive for the defendants in this particular case to collect a sales tax and then send it along to the government? I understand your argument, and my next question is going to be very simple. you said at the outset, this is really a consumer-driven statute. It's not meant to punish the merchant. But if we're to take what you're saying at face value and to rule in your client's favor, aren't we really punishing the merchant in the terms of travel damages, actual damages that were incurred, attorney's fees theoretically, because they complied with a government directive?
No, and here's why. And I'm not in the business of suggesting questions, but I think it's worth interrogating. What is a merchant? And they've been saying all the time, what were we supposed to do? We emailed someone at the Department of Revenue. That's not binding guidance. They could have asked for binding guidance. They changed their mind a couple of times, and we just went with whatever the most recent person said. But what were they supposed to do? They were supposed to find out the law that applied to their enterprise, make a definitive determination, and execute that. Conduct their business in compliance with the law. That costs money. And if their answer is, we're just going to email someone at DOR, and that allows us to potentially overcharge tax to consumers, is there a profit motive there? It sure seems like that affects the bottom line.
How does that affect I can't think of any merchant in the Commonwealth of Pennsylvania that enjoys charging people sales tax. I mean, I don't know. In fact, they're looking for ways not to charge people sales tax because it gives them a better advantage. And so I would like your reaction to that, but I'd also like your reaction to this. You said they could have gotten binding guidance from the Department of Revenue.
Yes.
What binding guidance can the Department of Revenue issue absent promulgating a regulation or issuing an adjudication?
There is a mechanism in the statute that we've outlined in the brief, as I understand it, where you can obtain essentially a safe harbor letter that says, hey, this is our interpretation of the laws. It's like a formal opinion versus, an email from an employee on a Tuesday. That's the procedure that we've outlined.
Well, that's not binding guidance. That's what you said is a safe harbor letter. It may protect them from prosecution from the department.
Precisely.
But doesn't necessarily protect them from if you have a unfair trade practice and consumer protection law claim, it wouldn't necessarily protect them from that.
Right. So go to the department, get their guidance, find out what they think you're going to do. I'm sorry, they think you're required to do. And then perhaps you have arguments about estoppel and all the sort of arguments that they raised below. And by the way, didn't get certified on appeal now because they want to talk about whether some things you do in the course of running your business aren't part of your business. But you do that, and then you're safe on the revenue side. But I think it's telling because it cuts both ways, Justice Brobson. And you see it in their brief. In their brief, they say, well, if we have to comply with the UTP-CPL, if sales tax decisions are reviewable as deceptive, well, then obviously we're going to tax people less, and that's bad for the public fisc. Well, that cuts the other way.
No, they're messed up either way. There's no win for them. If you're correct, there's no win for them. They have to be absolutely perfect, because if they're not perfect on everything on the collection of the tax, if they don't charge enough tax, the Department of Revenue is going to come after them. And if we recognize a Unfair Trade Practices Act claim, a plaintiff class action law firm is going to find enough plaintiffs, and they're going to sue for class action.
It's true for unfair, deceptive acts in the insurance industry.
Even though the General Assembly has said the remedy per consumer is to seek a refund.
That's absolutely true. You have to conduct your business in compliance with the law and not deceive consumers. It's true for insurers. It's true for housing providers. It's true for bankers. These are all heavily regulated industries.
You can see this is a different matter. This is tax. I mean, you want to lump it in with Greg and all these other cases, but this is tax collection. So what if the Department of Revenue, they make a retroactive change and say something's tax exempt, but they've already collected the sales tax from the buyer? What do they do in that scenario to avoid liability under the CPL?
I'm sorry, can you repeat that, Justice?
So that there's a determination by revenue that this is tax exempt, but the tax has already been collected. What do they do to avoid liability?
So I think that's where guidance comes into play. It's a cost of doing business. There's all kinds of legal compliance requirements that can expose you to liability on the other side of your business. It's part of the cost of doing business. You know, it's true that you can get yourself caught in a
This connects to Justice Brobson's what I call his whipsaw question, right? Because they're between the rock and the hard place, right? They're between the department and the potential treble and punitives on the other.
right.
Whereas prior to you coming here, the only thing they had was, well, if we're wrong, at least the consumer has a refund remedy.
Right. And that's great for the Department of Revenue, and that's great for the merchant, but that uncertainty is being priced out to consumers.
How does that happen? How is that being priced out to consumers?
Yeah, well, I mean, this is a great example. Let's say there's ambiguity about the taxability of a particular item. What are the incentives here? If it's arguably taxable, tax it. Revenue is not going to complain. I don't think so, anyway. And then, who pays for that ambiguity? Consumers pay
But
for
the
it.
money's been upstream to the state. There's not a deception motive pled in this. Did you plead that? Did you plead that they've siphoned the money to their treasure, to their pockets?
Well, Justice Weck, there may not be a deception motive. There may not be intent to deceive. It may not be reckless or even negligent. But is the consumer being charged more? Well, I'm sorry, are they being deceived as to what they're paying? And they are.
Because the retailer wants to profit the state? Because the retailer wants to get more money to the Department of Revenue?
No, because the retailer wants to avoid problems with the Department of Revenue, and he says, let's just export the cost to the consumer.
Well, but you know, you're also aware that class actions are filed against the Department of Revenue for refunds, right?
Yeah.
If there is a common practice of retailers overcharging for sales tax, and this claim you say exists under the UC Unfair Trade Practices Act, then why has it been for the last how many years that class action lawyers have been suing the Department of Revenue to get refunds of taxes, sales taxes in particular, that shouldn't have been paid?
Yeah, I mean, I don't have an answer. I don't know.
Maybe it's because nobody's come up with this theory before, because it isn't really a solid one when you're considering it's the Commonwealth who is benefiting from this transaction.
Well, respectfully, before Greg, no one had said, that deception is itself actionable.
Well, and aren't we looking in this Consumer Protection Act not with who benefited on the sales side, but who was there a detriment to the consumer?
That's precisely correct. And look, Greg talked about it at length. The courts in Pennsylvania, when the statute was enacted, some folks felt really comfortable with the common law, and so we started engrafting these new elements from the fraud tort and all these other things. And I think why Greg was such a watershed moment is it says, no, we're going to look at the text. And I hate to use the dog that didn't bark canon here, but if the sales tax existed before the UTP CPL was enacted, if you talk to an average business owner, they're going to say that one of the things that they do in the context of their business is I comply with tax laws and sales tax laws. And the legislature said, I don't think, well, they didn't say, oh, well, if you're a government agent and you don't have any motive, then that doesn't count. That's not textually there. And I think what the argument that my colleagues are making here is that the legislature is hiding an elephant in a mouse hole. Because if we're going to say, in this language, that may or may not be a copy of the Federal Trade Commission Act, but that's maybe that's not necessarily where we are analytically. If we're going to say we're going to exempt this whole category of things that businesses do that, by the way, still can deceive consumers, are we going to hide it in this kind of circular definition of trade and commerce? Or when we're talking about real government agents, are we going to say they're not even people? They're not in the statute. I don't think that it's the business of the legislature to hide from the court. Maybe sometimes they do it, but to hide from the court who it intends to be in and out of the statute and what the conduct. Now, look.
I don't want to incorporate criminal law principles into what we're talking about here, but you're asking us pretty much to draw a bright line into and impute certain principles into this particular act. In other words, you want us to impute strict liability principles into the consumer protection law regardless of mens rea. In other words, I don't care if they intended to deceive. I don't care if they did. This catch-all provision allows us to kind of proceed via strict liability.
Yes, I think that's what Greg did. I think that's what Greg did.
That's unquestionable. The question is, do you get to this tax piece?
Right. And I think if the legislature wants to carve out this vast swath of activity that businesses are engaged in, it says it a little more explicitly. But look, what they did say was in the conduct of. Now we've just heard 2 hours about killings that occur in the conduct of a felony. Murder isn't a robbery; it's not itself robbery. This is how we say we refer to an overall mission or an overall enterprise. And we've cited a couple statutes that talk about that. Fraud in the conduct of your election duties. Defrauding people is not an election duty that I'm aware of. Discrimination in the conduct of your business. Discrimination is not itself business, I hope. Using automobile dealer plates in the conduct of your administrative functions. Driving to the meeting is not an administrative function, but it's this broader category of stuff that you do so that you can do business. And here's why it has to include things that are beyond advertising, selling, and distributing goods. In the UTP CPL, there's a provision that talks about failing to comply essentially with a warranty. Product's already been sold. It's already been advertised. It's already been distributed. You're not living up to what you did. Why is that in the statute? It's part of the overall enterprise.
Well, that's a classic consumer protection provision. I mean, that's like the granddaddy of consumer protection. But if you win here, what aspects of regulatory compliance would be beyond the reach of the CPL?
Yeah, and look, we talked about this in preparation a lot. Where are the limiting principles coming from? And I think the major limiting principle is the consumer deceived, right? Because that's the catch-all. Fraudulent acts, now fraudulence, a different question, intent, reliance, all these sorts of things. Deceptive is this activity something that's deceiving consumers? So for example.
Or is it something that the merchant intended to deceive the consumer?
Well, I'm not sure that an intentional deception is anything different than fraud.
Well, but I mean, doesn't deceive by definition, if you're going to deceive someone, doesn't the word connote some level of mens rea in and of itself?
If you deceive someone, there is a mens rea. If you engage in deceptive conduct, there is no mens rea. It's strict liability. That's the bottom line of Greg.
We crossed that bridge.
Right. We're through that. It's kind of like strict liability.
Well, it's a deceptive act. The statute says a deceptive act.
Right, and that's what Greg said. We're not worried about intent.
That gets directly then to the question: was the consumer deceived?
Precisely. But look, so we have this warranty provision. If we're just talking about buying and selling, it simply can't. That's out of the statute. We've drawn a line through it. Same thing for making substandard repairs. That's another specifically enumerated statutory provision. The Attorney General, who, by the way, has regulatory promulgative authority in this case, adopted a whole chapter of the Pennsylvania Code that's cited in the brief. It's the Automotive Industry Practices Regulations Act. It's a little wordy, but it talks about things like not forwarding the tax and the fees and the title fees and so on to the department in a timely fashion. It talks about not writing down your odometer reading when you take the car into the shop. It talks about not driving your car around while it's in the shop. These are not things that have anything to do with the purchasing and selling of goods, with the advertising of goods, or with the distribution of goods. These are things that occur in the overall enterprise and include taxation.
But they were all of those things were incidental to the service and the product that they were offering. It was in furtherance of what they were being paid for. They were being paid. They were being paid to deliver the title, to drive the car to make sure it's operating because they were being paid for the service. They're not being paid by the consumer for anything related to the sales tax.
Well, again, the regulation talks about not forwarding taxes and not forwarding title fees to the department in a timely fashion.
But
So if you're an agent when you're collecting taxes and we're outside the statute, then we're drawing a line through that regulation too. It's gone.
But wouldn't you have to? That's what I'm trying to tease out the regulatory activity on the one hand and the commercial interest on the other. I guess clearly, if the pleading were something along the lines of a siphoning off or a mischaracterization by the retailer, they had set up something at the register where the consumer got something that said tax, and it was going right to the retailer. That obviously we've got a CPL problem there, but here you've got a collection for the Department of Revenue, and then there's a recharacterization of the exemption or the non-exemption, so I guess where's the deception if the activity was not done in pursuit of the retailer's commercial interest?
So if this were the Punish Lying Retailers Act, I'd agree with you 100%. If the private action provided a remedy for ascertainable ill-gotten gain to merchants, I would be with you 100%. But it doesn't. It provides a remedy for deceptive conduct resulting in an ascertainable loss. That's what the text says. That's where we are.
When it brings us back to the point is what Justice Wecht is describing is the collection of a sales tax on behalf of the Commonwealth and remitting it to the Commonwealth part of, is that the trade in business of the consumer? That's driving around a vehicle or not driving around a vehicle when you're supposed to be taking care of it is clearly within the trade of business. Honoring a warranty that you sold is in the trade or business. The real question is collecting the tax that the state tells you have to tax to remit it to them, is that part of your trade or business?
Right, and look, they're not doing it for their personal edification. They're not doing it for some non-business purpose. They're doing it because they want to be in the business of buying and selling goods. This is part of the overall enterprise of being a merchant. You have to comply with the law, whether it's sweeping your sidewalk outside, whether it's, let me give you another example. Let's talk about the Act 6 pre-foreclosure notice. I think that's an interesting example. So could I come tomorrow and say, hey, the foreclosure agent came forward and they said, okay, we're foreclosing, you have 10 days to give it over or we're going to bust the locks out. Under their theory, and this is why this issue, I don't want to impugn motive, but I think this is why they selected the issue they selected. Because what they want is a way to carve out conduct that they can tether to some regulatory requirements. This may be just about sales tax today, but tomorrow it's about every notice that's required for every consumer transaction that may or may not be required. It's about every other legal compliance issue, and we'll say, no, we're just doing what the state tells us to do. But the misleading part of that is the whole point of what they're doing is so that they can sell goods to Pennsylvanian consumers. They're not doing it for fun. If we go back to driving your dealer plates, if you drive with your dealer plates and you're going on vacation, that's not in the conduct of your administrative functions. It's not in the conduct of your business. If you're driving to a business meeting, the meeting exists so you can be in business. That's what this statute is intended to encompass, is everything that you're doing so that you can get access to that consumer market.
So then your answer to my prior question about regulatory compliance is nothing would be outside the ambit of the statute. Nothing that a merchant does to comply with the law would be outside of Section 3. But the other provisions in the Act, whether it's the ascertainable loss requirement, whether it's the deceptive requirement, so on and so forth, those provisions really delimit what's going on here. It's consumer-facing transactions. We're not talking about business to business. We're not talking about my lease with my commercial landlord, things like this. We're focused on
deceptive and unfair practices in the conduct of your trade and commerce.
All right, I think we understand. Are there any other questions for Mr. Woods? It was well argued and a creative argument. We will take that under advisement. Let's hear from the appellee.
Good morning, Your Honors. May it please the Court. Jonathan Ellis. I'm here on behalf of the appellees, defendant appellees in the first case. I plan to address and I'm happy to answer questions about any of the aspects of the shared question presented here. Counsel for Footlocker is also here in the related case. He will address the court after me and can answer any further questions that you have.
And you're here for American Eagle.
I represent 9 of the 12 defendants in the first case, but I'm arguing on behalf of all the defendants in the first case. The Superior Court correctly held that the CPL does not include collecting sales tax within in the conduct of any act. It's not taken in the conduct of any trade or commerce for 3 reasons: the plain text, uniform precedent, and the consequences. First, the plain text of the act forecloses Mr. Garcia's claim. As defined in the act, trade or commerce is defined as 3 distinct activities: the sale, the advertisement, or the distribution of goods or services. Collecting sales tax is not in the conduct of any of those 3 mercantile activities. As a matter of Pennsylvania law, collecting sales tax is done on behalf of the Commonwealth. It's not done by a retailer in its private business capacity, but as an agent of the Commonwealth. The funds, as soon as they are collected, are deemed to be provided directly to the Commonwealth, and whether they are properly or improperly collected are the Commonwealth's funds immediately upon collection.
You would concede if there was any portion that wasn't remitted to the Commonwealth that you could be exposed, right? You would concede
I think that's a different case, as the concurrence recognized below. There has been no allegation in this case that the funds were not remitted to the Commonwealth, and I think it is on the plaintiff to make that allegation.
Okay, so you'd concede, though, that hypothetical? That if that were pled, for example?
If that were pled, I think it's a different case. I think it's a different case both on the plain text of the act. I think it's a different case on the precedent and a different case on the consequence. I don't think the court needs to reach it
how
here.
could they plead that, though, when you haven't gotten to discovery yet? They simply don't know what you do with the money.
I think the easiest way to find that out would be to actually seek a refund of the tax that they paid from the department. And if the department comes back and says there's no refund to be give you because there's no collection of that record of that tax being collected and sent to the Commonwealth, they'd know. And then you'd have a different case, and you can make an allegation in your complaint and make that claim. But that's not what's happened.
You could also do pre-complaint discovery. If that's the theory that's recognizable, you could do pre-complaint discovery.
I'm not entirely familiar with how that would work in this context, Your Honor, but it may be an option as well. The second reason that the collecting of sales tax is not within the CPL is the uniform precedent on the other side of my friend's claim here. The state and federal courts, everyone to have considered this question and issued a reasoned decision, has recognized that collecting sales tax does not fall within the conduct of trade or commerce within the meaning of the Pennsylvania CPL or the UDAP statutes similar with identical language in other states. The High Court of Massachusetts and the Connecticut Court of Appeals more than a decade ago held that collecting sales tax does not fit within the identical language within their statutes, and 3 different district court judges in the Western District of Pennsylvania have recognized the same under the Pennsylvania CPL. We think those decisions are persuasive in their own right, and the court should pay deference to them. We also think that they are awarded or warrant great deference under Pennsylvania law, at least the ones from Massachusetts and Connecticut, because they interpret identical language in the same model law. And the third reason that collecting sales tax does not fit within the conduct of any trade or commerce under the CPL are the consequences of a contrary ruling. Deciding the taxability of retail sales of goods involves fine distinctions and judgments that are not always intuitive on the face of the code or the department's binding guidance. This case well demonstrates that. It wasn't at all clear until January of 21 whether cloth masks but should be thought of as medical supplies that are untaxable, or everyday clothing, or an accessory that is taxable and has always been taxable. Whether a 5-ounce energy drink is taxable turns on whether it comes in less or more than 4 ounces. Whether a tie is taxable turns on whether it's formal or informal. These are not the sort of distinctions that courts are well situated to make or are vested with the authority to make in the first instance. And yet, Mr. Garcia would have retailers pay a penalty of $100 per transaction if a court ultimately finds that the retailer has predicted incorrectly the answer to those questions. Ultimately, there's no need to create such an impractical scheme, and there's no evidence that the legislature intended to do so. As been recognized this morning, retailers have no profit motive to overcharge sales tax from their consumers. They don't retain those funds. All it does is increase the price of their goods.
But Mr. Woods argues that the profit motive is not determinative. I don't know that he argued it was irrelevant, but it wasn't determinative because the question is, how was the consumer impacted, not whether the merchant profited.
So we do think the profit motive is relevant in a couple of different respects, and I guess I'll start with the ones that I think affect the consumer and their experience. The first, I think, is just the likelihood of that occurring at all. I think that if you look at the CPL is intended to regulate private mercantile activity. It's intended to address and change the incentives for exploitative merchants so that that are driven by a profit motive in some cases to engage in unfair acts and practices. We think that makes those practices more likely, and for a consumer to more likely suffer those. And so I think in that respect it matters to the consumer's experience. It's just less likely to happen. And the other way it matters is really the opportunity for redress, where there is a profit motive driving the retailer's conduct because they are keeping the funds. Your Honor, I don't want to.
Yeah, but I'm following you. I guess my quizzical look, I think you're responding to my quizzical look, because it seems like part of their theory might be that in an uncertain or new tax environment, they're shifting to you. I'm sorry, you're shifting to them the cost of predicting where the tax liability will be. They're saying in effect that you overtaxed us and put that cost on us, and we ought to be able to come at you for that deception.
So
putting intent aside, it was an uncertain environment with these masks, COVID, et cetera, et cetera. So you just said, pay the tax, and now it turns out they weren't liable, and they want a remedy from you because you couldn't be bothered to figure, even though you had the superior capacity ostensibly to find that out, you didn't, and you shifted that cost to them.
So I don't think that's a fair characterization of what's happening here, nor is it really a realistic way to look at how this would go. As I was just saying, the retailers have no incentive. The profit motive points the other way. We don't want to charge any more taxes than we have to, because if we charge taxes that we are not required to charge, all it does is effectively raise our prices as compared to our competitors, and so lowers our profits. And it's also not fair to say that there was nothing done here. If you look at the record at 230 and 233, those were questions that were asked about whether cloth masks were taxable, and the answer was no, or yes, they are taxable until January of 2021. I think that was the better reading of the guidance from the department and of the law. I think what we're really saying is that we should take the risk. We should bear the risk, and not just to pay back the tax, but to pay $100 per transaction penalty. And I think that is just not what the legislature intended. And I think what the refund mechanism demonstrates is that the legislature had another mechanism in mind, an out-of-court efficient mechanism. It's taken advantage of by thousands of consumers every year.
Isn't that also, that's part of the answer, right? Is about this shifting of the risk or burden. The General Assembly has said, there is uncertainty, and that's why we're giving a refund remedy to the consumer if the consumer feels that they have been overcharged. And so it's the General Assembly that's shifted that burden or risk.
Absolutely right. I do want to address this idea that we could have sought more guidance with sort of a binding guidance. That gets us nowhere. I think what we'd established in the conversation this morning is that even if we had something more formal than the Q&A that we had, and what that said was what the Q&A said, those are taxable. And then it came along later, and with the 21 guidance, it said, you know what, actually it's not. They were not taxable. Now, we have a safe harbor against the department, but under his theory, we're still have committed an unfair or deceptive act or practice, and the fact that we didn't think we were is no different than this case. We haven't. There's no allegation that we didn't take the utmost care in trying to charge the proper amount. And as we've discussed over and over this morning, the scienter doesn't apply here. There's no mens rea. So the fact that we thought that we couldn't, we had to charge sales tax here isn't going to protect us from a CPL claim.
But that's his point. I have a little bit of a harder time getting over this notion that the charging and collecting the sales tax is not part of the sales transaction. That's certainly encompassed within those types of activities that we look to in enforcing this act.
So I think that's a matter really of Pennsylvania law, that it is not. The retailer's wearing a different hat when it's collecting sales
Oh, you're
tax.
saying it's a matter of Pennsylvania law. We're being asked to say that as a matter of Pennsylvania law, collecting the sales tax is indeed part of the sales transaction as anticipated in this act.
Right. So I kind of proceed in two different steps. First, you start with the CPL, and you ask what are the kind of activities that the CPL intends to regulate.
Sales.
Sales. That's
There
right.
you go.
Yes, private mercantile activity is what my friend recognized this morning, I believe. Sales of goods. And I think that Chief Justice Castile's concurring opinion in the Meyer decision is helpful, right?
Well, first of all, that was Judge Pellegrini's quotation that appears in Justice Castile's concurring opinion, which was an excellent statement of something. But this notion of exempting the performance of public duties is a much broader proposition than what we're talking about here.
I think what we're asking here is for the court to recognize that collecting of a sales tax is an act that is not in conduct of a sale, that the retailer is wearing a different hat. The Gray case that we talked about already this morning says it explicitly, that the retailer is acting as an agent of the Commonwealth there, and that was entirely relevant, although it rose in a refund case. The whole idea was once you give the money to the retailer, the statute of limitations for filing a refund petition has begun, because you've given it to the Commonwealth, because the retailer is acting as an agent in that capacity.
But individuals who bring claims under this statute oftentimes, many times, have breach of contract actions. So what?
Yeah, I think there's multiple things in this case that indicate that collecting a sales tax is not within the trade or commerce. It's true that the alternate remedy that's provided by the legislature is a powerful part of that story, but actually I think there's a lot more than that. I think, as I was saying, that the fact that they're acting as an agent of the Commonwealth indicates that they are not acting with their private retailer hat on when they collect that sales tax. The fact that the tax code says that the collection of a sales tax has to be done alongside making a sale, not in making the sale, not with making the sale, but alongside of it. The fact that the tax code says that when you're advertising, you have to separately advertise the price that you're charging in the sale and the tax that will be collected, that you cannot tell consumers that you're going to absorb that price. I think those are all strong indicators that these are different tasks, and they are not, that this is not inside the sales that are reached by the CPL.
You're looking for an exception.
No, Your Honor, I disagree with that. We're looking for an interpretation.
I'm not suggesting that is necessarily wrong, but I'm just saying that I have a hard time separating the collection of a sales tax from the sale itself. I mean, that is indeed part of the transaction, one that has to be done in order for the retailer to be in business. They have to collect sales taxes.
So we are not seeking an exception, Your Honor. We are seeking an interpretation of what it means to be in the conduct of trade or commerce. I think what I heard my friend say this morning, I think he eventually said it right explicitly, that he thinks that phrase does no work. that any conduct that is taken by a retailer is in the conduct of their trade or commerce. And that cannot be what the statute meant. The legislature is not in the business of adding in whole phrases and definitions of those phrases that do no work. We are asking the court to enforce the limitation, the element of a CPL claim that requires the conduct to be in the trade or commerce. And I think if you look at the court's cases in Massachusetts, the Feeney case or the Blas case, or the other cases interpreting CPL in the district courts, you'll see that none of those decisions are writing exceptions into the law. They're all interpreting what it means to be to take actions in the conduct of trade or commerce.
I know this maybe is not germane or takes us back a few steps, but why is the issue whether this is in the conduct of any trade or commerce within the meaning of the law, rather than whether this can be an unfair method of competition and unfair or deceptive acts within the meaning of the law?
So we advanced several different defenses below, but I think the one that we're here before this court on is whether it comes within the conduct of a trade or commerce. That's an element just like the unfair or deceptive act.
Why is it that and not the other? In other words, why is the issue whether the collection of tax is in the conduct of any trade or commerce rather than whether it can be unfair method of competition and unfair or deceptive acts?
I'm not in the business of telling the court, how we should win. I'm happy to take a win on any ground. But I think the reason that we advance this argument and the reason that the other courts, to address your question, Your Honor, have done this is because there is a definition in the code of what that means, that it has to have a real limit here. It has to, and it is defined, I think, rather not limitlessly, but as 3 distinct acts. And I think that the code indicates both the CPL itself as well as the tax code, Pennsylvania tax code, suggests that this is outside that limitation.
Because the reason I asked it, not to belabor it, but Justice Donahue's question surfaced for me the possibility that the collection of tax, though it's on behalf of the state, could be within the conduct of any trade or commerce, but nonetheless, as a matter of law, not be an unfair method of competition, an unfair or deceptive act, absent a pleading of siphoning or what have you.
Sure. We do not think that we engage in an unfair act or practice here, Your Honor. I just understand the court to be grappling with a separate question today. And I think our argument is well-founded. Indeed, it is the unanimous view of the courts that whatever it means to be the catch-all phrase, certainly hasn't pointed to any of the enumerated phrases, that this is not an act that was done in the conduct of any trade or commerce. And I do think but
you could have argued, or maybe you will still have an opportunity to argue, that this, what is being alleged, does not fall within the category of one of the 21 enumerated.
We did, Your Honor. We advanced that below. We haven't advanced it in this court,
Right.
But we did make those defenses. I was going to say, though, I think the enumerated unfair acts and practices here do have relevance even to the question that the court is grappling with today. And I think it just reinforces, if you look at those list of acts, they are all ones that a retailer takes in their private capacity, in their profit-seeking capacity. And I think it just reinforces what I think Chief Justice Castile and Pellegrini, if I said that correctly, had found in the Meyer case, both here in this court and below, that really what the target is private mercantile activity. And I think that when you're undertaking a government obligation, specifically this one, specifically the collecting of a sales tax, where the retailer is an agent of the state and the funds are collected for the Commonwealth and transmitted to the Commonwealth, that's just not the sort of private mercantile activity.
I guess, Judge Pellegrini, at the time President Judge, wrote the dissent in the lower court in Myers, and that's where that often cited quotation comes from. But here's my problem, very basic one. It's called a sales tax. The only entities that impose this tax are people who engage in sale. I mean, I could buy an argument that maybe it isn't an unfair practice, but I mean, to suggest that this is outside of the realm of commerce as is anticipated in this act strikes me as a stretch. As I said, I think you'd have to call it something else, like it's an exception. They are acting as an agent for the state, not as someone conducting a sale. See, I find that a stretch.
So I grant you, Your Honor, that it happens at the same time, right? But I think it happens separately, and I try one more time to persuade you of that. Yeah, I know. But I think if you look at the court's decision in Feeney, I think it includes a good description of this, as well as the court's description case, the analysis in Lazovsky, which is a Western District of Pennsylvania.
But from your
case.
perspective, it's a separate transaction. But from the consumer's perspective, it's one seamless transaction. And so I guess it's a question of the lens, how wide or how narrow we want to draw the lens here, or should draw the lens. Because viewed from a consumer's perspective, perhaps, all of these things are costs of doing business for you, all of which you're absorbing in pursuit of the bottom line at the end of the business venture, which is some profit, hopefully for you, right? So that you're expected to absorb all of these costs, and it's on you from their perspective if any of them have had a deceptive effect. So it's not because it's not an intent based.
Right, I mean, of course, in some sense, everything that we do as a retailer is toward the profit making, right? So is the hiring, so is the buying. But we know, right, from Chesapeake Energy that the buying is not within trade or commerce. I don't think anyone really thinks that hiring is within the conduct of trade or commerce, within the CPL. It cannot be everything that we do. And so then it really comes down to your point that to the retailer or to the consumer, it's one transaction. And to your point, Your Honor.
And that's your opposing counsel's point. I mean,
right.
But to me, to suggest that it is somehow unfair competition is a very large leap. And that's sort of the underlying argument here, which is there's no profit motive. They aren't making any. So, I mean, unfair competition means to me that you're doing something to put yourself above your competitors in the marketplace. This would be the antithesis of that, but that doesn't mean it's not in the context of a sale.
Or to incentivize the consumer to buy your goods in a way through some deceptive act.
We do not think that we engage in any deception or unfair practice here. And
but there's nothing about separately line iteming a sales tax that incentivize a consumer to purchase at your store versus some other store.
Absolutely not. There's certainly nothing about collecting a sales tax that we don't owe that's going to incentivize a consumer.
See, my concern is here somehow limiting the notion of what a sale is in the context of this act. That to me is something totally unnecessary under the circumstances of this case, and certainly in the context of the fact that this is a seamless transaction for the consumer, and that's who we're focused on. So, I mean, so to somehow make a sale something narrower than appears on the face of the statute is, I think, a dangerous proposition.
So I'd love to address, if I could, the concern about sort of the knock-on effects here, and then I'd like to come back to why I still think it is a different part of the sale, a legally different one. But to the sort of slippery slope idea, I think the best I can point you to, Your Honor, is the fact that Massachusetts decided this question as clear as day in the High Court over 10 years ago. The Connecticut Court of Appeals decided it over 10 years ago in a binding decision. No court in the land has granted this sort of claim when it grappled with this argument. And yet, what my friend can't point to any actual adverse consequences to that. We've had over a decade in those states of it being crystal clear that a collecting of sales tax is not in the conduct of any trade or commerce, and there haven't been any sort of seeping bad effects in other parts of their consumer protection statutes that I'm aware of or that my friends has identified. So I don't think you should have concern about the next step on the chain.
I lose sleep over things like this, so I will be concerned about it.
Okay, any other questions for Mr. Ellis? Well argued. Let's hear from your co-counsel, Mr. Martin. Seems like Mr. Ellis covered just about everything, but if you have anything to add, we'd love to hear it.
Mr. Ellis did cover everything, and I take the admonishment literally. I will add only one thing to the immediate discussion where we left off about sales tax and the concern about sales. I would focus that on the word tax. And the difference here in the analysis is that the prerogative to tax, the imposition of a tax, and the directive to tax starts with and comes from the government. It's not something that the merchant dreams up in the context of the sale. And I think that's why we can take this out of the statutory scheme because of where the prerogative and directive comes from. So that would be my point to add to the analysis. And thank you.
Does anybody have any questions for Mr. Martin? Thank you. Well argued by all. Mr. Ellis, you were admitted pro hoc vice in our court. Where is your home?
North Carolina.
North Carolina. Well, you're welcome in Pennsylvania anytime. Thank you all. Mr. Minner, we're going to take a lunch break until 1 o'clock. afternoon. Would you call the case, Mr. Mayor?
In the interest of SW and minor, representing SW, Mr. Alex Welshon, representing children and youth, Ms. Alexandria Stryker, representing WW, Ms. Catherine Volponi, and representing appellees, Ms. Brooke McMorrow.
Good afternoon.
Good afternoon.
In this discretionary appeal, a child was removed from her mother's care, adjudicated dependent, and placed in the care of foster parents. Legal custody of the child was awarded to the local Office of Children, Youth, and Families, or CYF. After CYF sought to remove the child from foster parents' care, foster parents sought to intervene in the dependency proceedings under the judicially creative, quote, prospective adoptive parent, end quote, exception to the rule that foster parents generally do not have standing to participate in such proceedings. The trial court denied foster parents' motion to intervene, but the Superior Court reversed. The Superior Court reasoned that Section 6336.1 of the Juvenile Act, which was enacted in 1998 after the decisions announcing the prospective adoptive parent exception, seemingly abrogated the exception, unless a foster parent or pre-adoptive parent had been awarded legal custody. Nevertheless, the court determined that the trial court erred in denying foster parents' motion to intervene under traditional standing principles. We granted review to consider whether Section 6336.1 has in fact abrogated the judicially created exception that allowed prospective adoptive parents to participate in dependency proceedings and thus barred foster parents' intervention.
Thank you, Chief Justice Todd. My name is Tom Welshon. I'm with Kids Voice. We are guardian ad litem for SW in the underlying dependency case. Today, I will be focusing on the issue of the abrogation of the Superior Court case law by Section 6336.1a, and I'm going to emphasize the reasons why this is important from the perspective of foster children. Ms. Stryker from the Allegheny County Law Department will focus on the importance of this issue for the county agency, and Ms. Volponi from the Juvenile Court Project will focus from the perspective of parents. Today we are asking you to hold that pursuant to Section 6336.1a of the Juvenile Act, foster parents, including pre-adoptive foster parents, have a right to notice of every hearing in dependency court and a right to be heard at every hearing in dependency court. But unless they have been awarded legal custody of the child, they do not have standing for any purpose in the case.
That's the statutory allowance, right, to appear and be heard?
That's correct, Chief Justice Todd. Yes, we're asking essentially that the statute, which was enacted after the Superior Court line of cases began, be enforced, because we think that it hasn't been.
Can I just follow
Of course.
up on that? The statute says nothing in this section shall confer standing. Does that imply that there are other contexts in which standing could be conferred?
Justice Donahue, I have two comments to that. First of all, this is the only section in the Juvenile Act that references standing for foster parents or gives foster parents any rights at all. Second of all, we know when this statute was enacted in 1998, we know that prospective adoptive or pre-adoptive foster parents had standing to intervene to challenge removal of a child pursuant to Mitch and Griffin in that line of cases. So that starts in 1989. If Section 6336.1a simply said, nothing in this section shall give a pre-adoptive parent standing, then I think there's an argument that the General Assembly was allowing that earlier exception to continue. But that's not all the section says. If you look at the language of the last sentence of 6336.1a, it starts with this clause that says, unless a foster parent, pre-adoptive parent, etc., has been awarded legal custody. So they didn't need to do that. If the General Assembly intended that Mitch Griffin line of cases to continue, all they needed to say was they start with where it says, nothing in this section, then I think you've got an argument. But there's more. There's this first clause, and we can't, we shouldn't interpret a statute to say that language has no meaning or is superfluous. And I wanted to put this a little bit of a different way. If the legislature had intended the Mitch Griffin standing to survive, then they would not have included pre-adoptive parents as needing to have legal custody to have standing, because they already had it under Mitch. So if you look at, again, this last sentence, unless a foster parent, comma, pre-adoptive parent, this says they need to have legal custody to have standing. But pursuant to Mitch and Griffin, they didn't need legal custody. They already had standing. So my point is, this is doing, to us, this language is clear and unambiguous, that the General Assembly's intent was to abrogate this line of cases.
Counsel, they are both Superior Court cases, correct?
That's correct. That's correct, Justice Dougherty. It is without question, of course, that foster parents serve an important role to this system. And the General Assembly recognized that in Section 6336.1a. It does give them the right to notice. It does give them the right to be heard. But again, it's clear that unless they've been awarded legal custody, they don't get standing. The foster parents in this case had never been awarded legal custody. The Superior Court, the Superior Court understood you can't reconcile these earlier cases. You can't reconcile Mitch. You can't reconcile Griffin. You can't even reconcile MRF3 with Section 6336.1a.
Why am I even looking at those? Why aren't I just looking at what the statute provides? It's almost like you're asking me to look at prior case law to find an ambiguity or resolve intent of the General Assembly, when if I read this statute, and I think it's relatively clear, to Justice Donahue's point, is it's a notice statute. It's a notice and an opportunity to be heard statute. But the people that get statutory notice and an opportunity to be heard can't rely on that notice and opportunity to be heard as a basis for standing unless there are additional things to them. But that doesn't mean that they can't rely on something else to give them standing. They just can't rely on that statute to give them standing. What ambiguity in there that you can find within the four corners of the language allows me to look beyond it to cases that preceded it or some other external force to define legislative intent?
Justice Robson, I don't think there is ambiguity, and let me go back to the point I made about if...
Can you make that no ambiguity argument without referencing prior case decisions?
Well,
tell me in the statutory language, just look at the language and tell me what you think that language means based on what the words are chosen by the General Assembly, without reference to a prior decision.
Sure, of course. So I'm going to flip the language around, because the language says unless you have legal custody, you don't have standing.
Under this section.
Under this section.
Right.
Which, to me, if you flip it around, if you have legal custody, you have standing. That's an award of standing if you have legal custody. That's unambiguous. That's clear. That's our belief. Certainly, that was
the statute clearly confirms that.
That was the belief of the Superior Court in this case, was that they were constrained to apply MRF because this doesn't exist in a vacuum.
But the statute clearly provides for that. If you have custody, you can rely on this section for purposes of standing.
Yes, that's correct.
Okay. If you don't have custody, you don't have standing, or if you don't have custody, you can't rely on this section for standing.
If you don't have legal custody, you don't have standing.
Where does that say that in the statute?
I reference the language. Unless a foster parent, pre-adoptive parent, etc., has been awarded legal custody, nothing in this section gives them.
Nothing in this section. That's back to Justice Donahue's point.
I think we have to recognize that this line of cases did exist. We did have.
Why?
Because this section, I believe, directly affects that. This was let me back up. The Juvenile Act doesn't define who are parties in a case, but case law has established that parties to a dependency case are the parents, the legal custodian, and the person whose care or control is in question. That's been established. So we have, beginning in 1989, the Superior Court creates this exception to that and says, we all know that this has been the way it is, but we're going to add another layer of, another class of people who have some standing in a dependency case, and that's what Mitch was, and that's what Griffin was. Prior to that, there was no grant of rights to foster parents at all in the Juvenile Act. In 1998, the Juvenile Act was amended to give foster parents rights. It gave them the right to notice. It gave them the right to be heard. But
it didn't necessarily give them standing.
I'm sorry, Judge?
It didn't necessarily give them standing?
It did not give them standing. It says, it's our belief, and I think it was the belief of the Superior Court in this case, that it says unless you have legal custody, you don't have standing.
Under this section. See, that's what I'm saying. The history tour is interesting to me, but under the Statutory Construction Act, I don't get to look for the history tour if the language is clear and unambiguous. The history tour is a tool, the nature and occasion of the statute, why it was enacted, and we can look at decisions there. But if the language is clear, we don't get to do the history tour.
I appreciate that, Justice Brobson, and it's our position that the language is clear. It's our position that there's no other section in the Juvenile Act that would grant foster parents, pre-adoptive parents, any of these people standing at all in any dependency case. The fact that it says nothing, there's nowhere else that this could come from.
Well, it could come from common law. It could come from William Penn parking. It could come from, we have a lot of common law out there in terms of people's ability to have standing to intervene in all kinds of judicial proceedings.
Right.
You're saying this language excludes all of that. Clearly and unambiguously.
Without legal custody, yes. The reason that I think that this is important, and the reason that I told you I want to address this from the perspective of foster children, is because if the decision of the Superior Court is affirmed, we have a situation where people who identify themselves as prospective adoptive parents now get to come to court, and now they get to argue that they are prospective adoptive parents, and they have some standing in the case. The standing that's been outlined in Mitch and Griffin and MRF is the standing to challenge the removal of the child from their home. But if we are in this situation, this will undoubtedly lead to delays in permanency for children. As foster parents litigate the issue of whether they qualify as pre-adoptive or prospective adoptive parents, if the trial court denies that request, like it did in this case, the pre-adoptive parent gets an opportunity to go to Superior Court.
Counsel, excuse me.
Yes.
Pre-adoptive parent would be a family that has, particularly in an agency adoption, you would have to have the approval of the agency, correct?
These are highly fact-specific analyses, Justice Doherty.
The prospective adoptive family in this particular case no longer is in possession or control of that child. Is this family?
You are correct. The child was removed in September of 2022.
Okay. And now we have a second family. Has the agency indicated that this family could now be a prospective adopted family?
I believe the agency has, and I believe that the trial court has as well, because of course we have SW at the intermediate appellate court level, which says prospective adoptive parents have standing here. We now have a hearing that is scheduled as a result of the Superior Court's decision in this case, where the former foster parents have counsel, they have standing, and the current foster parents do as well, because the issue is, will the child be removed from their home? And so now we have multiple layers of foster parents or former foster parents who have standing to challenge this very narrow issue. I'm not saying that this is standing in the entire case. It's a narrow issue. But what it's done is delayed permanency for this child. And it will...
How does that happen, though? Because these people were entitled, at least under the statute, to a notice and opportunity to be heard, right?
Yes, that's
the only thing standing gets them beyond that is an opportunity to appeal,
which has delayed this case by many months.
I understand, but you were saying that the mere activity of the hearing was delaying, but the hearing could happen with the standing issue is only with respect to whether they get appeal rights.
That's correct. Yeah, that's right. But I mean, that's what it is. This child has now been in the current foster home for 2+ years. Permanency could have been achieved. The case was nearly ready to close prior to the Superior Court's decision in this case several months ago. It has stayed open. It will continue to stay open while this issue is resolved. That will happen for countless children across the Commonwealth. And keep in mind, just like in this case, this issue of intervention can be raised at any point. The procedural posture here was that the child had actually already been removed. The foster parents did not seek to intervene. The foster parents came back at a later point within a few weeks, but after a hearing on the removal, and at that point sought to intervene. If you look at the Superior Court's decision in this case, that's a discussion that they have. They say the rules of civil procedure don't require, and they say intervention can happen at any point. Our fear is that if the Superior Court's decision, which the Superior Court is saying, we don't think our decision can withstand scrutiny of the Supreme Court. If this court affirms that decision, that will be the green light for any foster parents who, again, we recognize that they serve a very important role, but we may have foster parents who have cared for a child for 9 months or 10 months who litigate this issue and then appeal this issue, and then things are delayed. And 12 months, 13 months.
I apologize for interrupting, because you raised something interesting about the delay. I noticed the delay in seeking intervention. Is that an issue that's in front of us as to whether they acted timely in seeking intervention?
It was an issue at the Superior Court. It's not an issue that you took, that this court took. We didn't.
Did you ask us to take it?
We did not, Justice Brobson.
Is the goal still reunification, or are you moving for termination?
Justice Doherty, rights have been terminated already.
Oh, okay.
That matter has been appealed. The Superior Court has affirmed the termination. This child is ready for adoption and has been for quite some time.
Have you done 2 family studies on both alleged pre-adoptive families?
So the former foster, what I'm referring to as former foster parents, had an adoption caseworker who was assigned to. I'm not sure where the adoption caseworker was in that process. The second foster home, the current foster home, they have done everything necessary to complete the adoption of the child. We're just waiting on the outcome of this situation. Unless there's any other questions, I've covered. We think that this is clear. We think that a decision affirming this will lead to further delays. With nothing further, thank you.
Thank you. Ms. Stryker?
Good afternoon, Your Honors. My name is Alexandria Stryker. I represent the Allegheny County Office of Children, Youth, and Families in this matter. I would primarily echo what Mr. Welshons has stated thus far, not to belabor the point. We believe Section 6336.1a is absolutely crystal clear. Without legal standing, a pre-adoptive or foster parent cannot, without legal custody, a foster parent cannot have standing under the Juvenile Act.
Could I ask you a similar question to what Justice Donahue asked your colleague? Pardon my interruption. On this nothing in this section language, is there a reasonable interpretation of that would suggest the legislature was just confining the analysis there to what's in that provision, indicating that other rules for standing survived? Is that a plausible reading in your judgment?
Your Honor, as counsel stated, this standing exception has been in effect in the jurisprudence for many, many decades. If the legislature wanted to memorialize this exception within the Juvenile Act, they would have done so, and they clearly made a deliberate choice not to, and that's really significant.
How do you know they didn't do that? I understand all of the arguments about the importance of permanency, and I get that, and I know how this tends to work against it, but why were they talking about standing at all here? I mean, you're suggesting that there's some clarity to this. Under the law, if a person has a statutory notice and opportunity to be heard, does that person then implicitly have standing? did the legislature have to say anything about the fact that notice and opportunity to be heard did not confer standing?
Your Honor, we believe if the legislature intended to award standing specifically, they would have used the word standing. And they didn't. They used notice and they used opportunity to be heard. The legislature this was floating around in the courts for decades prior to the enactment of this legislation. And they made a deliberate choice not to be specific within the statute that, oh, there is no prospective adoptive parent exception within the Juvenile Act anywhere.
But then why use the phrase? Why use the phrase, nothing in this provision shall confer standing? Doesn't that imply that there is another avenue through which standing may be recognized?
Not necessarily. It's significant that the Juvenile Act is the governing statute for dependency cases in general. That would be the arena in which to address foster parent standing if it existed.
Did this notice and here opportunity to be heard statute, did that exist in a different form before this nothing in this section language should be there?
Not to my knowledge. Are you talking chronologically?
Yes. Was it prior to this section, was there any section of the Juvenile Act that said these people get notice and an opportunity to be heard?
Not to my personal knowledge.
So it was all one section enacted at one time.
Yes, the entire Juvenile Act was enacted in 1998.
And you don't see a plausible construction of that for the General Assembly to say, we think certain people should have notice of these proceedings and an opportunity to appear and be heard, but we don't think we want that to give them standing in and of itself, that they would need to have standing some other way.
Yes, Your Honor. Notice of the hearing and opportunity to be heard are different considerations than standing generally.
Right.
Because standing affects the appeals, like your colleague was saying, Justice Brobson, and presumably also to call witnesses in the trial court, right?
Exactly, to present evidence, to cross-examine witnesses, to appeal matters. Standing is a very, very serious matter, and it's not something that courts take lightly. It's really significant. The Juvenile Act does not use the word standing in regard to awarding prospective adoptive parents or foster parents without legal custody.
So how would you have us read this? How would you have us read this statute? Unless what? Unless a person has legal custody?
Your Honor,
they have no standing? Is that how you want us to read this?
for the classes listed within that section, which includes foster parents and pre-adoptive parents, yes, without the legal custody, they cannot have standing.
So in essence, what you're sharing with us is the language, nothing in this section means the statute is now permitting foster parent to have notice and to appear. But within this section, the General Assembly is abrogating the judicially created concept of pre-adoptive foster parent and stating, despite the fact that we're giving them notice and the ability to appear, it is not implicit standing. In fact, the only way you get standing through the statute is having legal custody.
That's exactly right, yes.
That's what I thought.
Counsel, what are you asking us to do as appellants? What happens next if we agree with you?
Well, broadly speaking, or in the terms of this specific case?
Do both.
Okay. Broadly speaking, we as the county agency are seeking clarity from this court. We have a number of responsibilities under the Juvenile Act that we have to follow in regard to the families that we serve. We are seeking clarity so we can administer that correctly and justly, and we can follow the rules as prescribed by this legislature and by the courts. We're seeking clarity here today on a broad scale. In this particular case, we are asking the court, in finding that the standing exception has been abrogated, that the former foster parents in this particular matter do not have standing as prospective adoptive parents and do not have a right to intervene upon that basis.
So that you can complete the adoption with the family that currently possesses the child.
Yes, the agency is in favor of completing adoption with the child's current foster family.
Who have legal custody?
No, Your Honor. The agency retains legal custody at this time.
Right.
which is typical of dependency cases.
Okay, all right, thank you.
If there's nothing further, I rest on my brief. Thank you.
Ms. Volponi?
Good afternoon, Your Honors. I'm here on behalf of the mothers whose rights have been terminated, as you've already heard. And as far as the questions that have been asked so far, the issue of standing is specific in 6336.1, but it does reference you to other parts of the Juvenile Act, specifically 6351, the dispositional hearing, wherein the court has the ability to give temporary legal custody or permanent legal custody to a foster parent or a pre-adoptive parent. There's also section 6357, which is the rights and duties of the legal custodian. So this not 6336.1 is not the only place where we're addressing legal custody. And I did, in our brief, and my colleague is here, but I do want to introduce her. Name is Andrea Gross. She is present as well. And we do find ourselves in a very unique position here today because by rule of Appellate Procedure 908, we are acting, we're on the side of the appellant in the argument, but we're actually recognized as appellees in this case. And the other unique thing is this is the first time in my 26-year history of working in child welfare in Allegheny County where you're seeing the county solicitor, the guardian ad litem for the child, and the parent attorney all in agreement. That has never happened before. So, but we did point out in our brief, and I do want to go to this because ASFA was pointed, the Adoption Safe Families Act became law in 1998, and our Juvenile Act was changed to reflect what we referenced in our brief regarding the portion of notice and hearing. We cite to Section 104 and Section 475.5 of the Social Security Act. And the language that we have in 6336.1 is very similar to that language, and I'm just going to read it briefly. So it says in here, the foster parents of any of a child and any pre-adoptive parent or relative providing care for the child are provided with notice of and an opportunity to be heard in any review or hearing to be held with respect to that child, except that this subparagraph shall not be construed to require that any foster parent, pre-adoptive parent, or relative providing care for the child be made a parties to such a review or hearing solely on the basis of such notice and opportunity to be heard. Our 6336.1 is the General Assembly putting this into the Juvenile Act. I also want to point out that there was the congressional hearings held when ASFA was enacted. We have cited that in our brief as well. And it's, I think, important to note that what they are talking about, opportunity and notice, is because they wanted foster parents or pre-adoptive parents to be able to come to the court and give information about the child because the child is in their physical custody, not their legal custody. And therefore, they might have very relevant information to provide to the trial judge as to what is actually in the child's best interest. So that notice and opportunity to be heard was to serve that purpose in ASFA, and we believe that's why the General Assembly, in the way they have set up the statute in 6336.1, but also referencing to 6351, the dispositional hearing, as I mentioned, and 6357, the rights and duties of a guardian, or excuse me, the rights and duties of a legal custodian. So we think it is very clear, and we haven't yet talked about the cases that happen. I want to point out quickly that 6336.1 has been amended 3 times since 1999 when it was enacted. The first time was in 2002, and at that time they added the subordinate conjunction of unless you are placed in legal custody, do you have standing? And that's where that started.
Counsel, before you move on to another topic, in the earlier part of your argument, did I understand correctly that we could read this provision, nothing in this section shall give, may in fact refer to the proposition that there are other sections within the Juvenile Act that may confer custody?
I think that's a fair read, but the reason I'm pointing out in 2002 when this was amended again, I think our General Assembly foreclosed that by saying unless you have legal custody. And again, you can give legal custody to a foster parent or pre-adoptive parent, or now kinship, because that's the next time we changed the actual, or the 6336.1 was amended, was February of this year to add in kinship resources as well. Anyway.
But I don't know how that helps your argument, because we know, because we're here, that the Superior Court and the trial courts have been allowing intervention. And if it was so clear what the legislature intended and that wasn't happening, you would think that they would have clarified it. But why are you rejecting my interpretation based upon your earlier statements that what the legislature was referring to here were other provisions within the Juvenile Act that might confer standing?
Well, I think the other...
That would take care of my problem with what does this mean, except as provided in this provision. They may mean there are other provisions in the statute that allows standing.
Clearly in the dispositional portion of the 6351, the court has the authority to make somebody a legal custodian on a temporary basis or a permanent basis, two different sections of that same portion of it. So yes, the court can do that, but what we haven't addressed yet is the case law that cites from the time 6336.1 was in place that the intermediate appellate court did not address, which is the whole line. This court addressed this issue in GC and KNL and a number of other cases. And you can see they were interpreting 6336.1 to mean exactly what we're putting forward here today, is that if you have not been awarded legal custody on another provision of the Act, 6351 in particular, and 6357, the rights and duties of a legal custodian, then it is foreclosed. So I think you have to also keep in mind that Mr. Welshance was pointing out that when this idea of legal standing was for pre-adoptive or prospective adoptive parents, it was 1989. And we had not had the Adoption Safe Families Act. We did not have 6336.1. I don't believe we had 6351 about temporary and permanent legal custody being awarded to other people. So I think, even though Justice Brobson didn't want to go on the history tour, I do think it's important for how this is where we are now.
Well, thank you for bringing this back to me. I think I understand better what your side's position is, but it seems to be relying on, and I think it necessarily relies on the idea that the statute is a comprehensive, all-encompassing box that leaves no room for common law anything. And therefore, if you don't have statutory standing, if you can't cite to a provision in the code that gives you standing, the General Assembly intended that you not have it, meaning that there's no, even though this court or the Superior Court has previously recognized some common law standing principles associated with the code, now we're supposed to interpret this language as being the General Assembly's intent to say, no, you either have statutory standing or nothing at all. Is that seems to be the anchor of your argument?
Yes, that's correct. That's what we believe the law is at this stage. And I do need to point out that the interest that we're talking about for biological parents is really clear. They have a fundamental liberty interest, a due process interest in their children. As we pointed out in our brief, that's just not true for pre-adoptive or prospective adoptive parents or foster parents. Their rights are solely created based on statute itself. You could look right now, if you wanted to, at pa.gov and see all the rules and regulations that are applicable to anybody who wants to be a foster parent or an adoptive parent. So their rights are derivative, and so the statute does define where that right is coming from. So I don't believe it's quite the stretch that when the common law standard was being introduced by the court in 1989, before we had ASFA and before we had these changes to the Juvenile Act. I think these changes are a direct result of the concept of trying to recognize the interest that the foster parent or pre-adoptive parent has, which is the opportunity to be heard and be able to talk about what's happening with the children. But it does not put them on the same level as what a parent's interest is in their kids.
Does anyone have any more questions for Ms. Oponi? Thank you very much. Let's hear from Ms. McMorrow.
May it please the court. My name is Brooke McMorrow, and I represent Aplt. And I'm going to start with the abrogation. The enactment of 6336.1A does not and need not abrogate the prospective adoptive parent exception. The case law has carved an extremely narrow exception to permit the limited participation of a foster parent who has attained prospective adoptive parent status.
And how does that survive the adoption of this statute, Council? It seems like when the legislature adopted this language in, was it 98?
Yes, that's correct.
That they did away with that, and that the courts should have woken up and smelled the coffee at that point that this exception was done. Why is that not the case?
Well, Your Honor, I believe that even in subsequent cases, there was a recognition that we cannot ignore the poll star being the best interest of the child. And so the foster parents bring something else to the table, and we can't overlook that. And so if you look at in the interest of GC, in 1996, that was actually beforehand, Justice Newman talked about the best interest, but then it carries over into in 2018 with MRF the third, where they affirmed the interest, this liberty interest that foster parents have, in that they're suffering a substantial and direct injury by virtue of children being removed from their physical custody.
But didn't the legislature indicate in adopting the statute that something that's intuitive, right? That the law doesn't really care about, so to speak, about the foster parent's interest. It cares about the child, right? So by providing the foster parents the opportunity to be heard and to get notice, that the legislature afforded adequate opportunity for the trial court to discern what's going on and make its determination without affording clients like yours standing, which could delay permanency.
Right, Your Honor. But the issue, especially in this case, is they really didn't have an opportunity to be heard. If you review the opinion, they didn't get to put on anything. They were shut out.
They didn't testify in the juvenile court?
They were not allowed to say anything.
They received notice, right?
They did, and they were there, and they wanted to speak, and they weren't permitted to.
But that's a different issue.
But that's what I was just being asked.
That's a trial court error at that level. That has nothing to do with intervening.
Understood. It was just a question that was posed, so that's why. I mean, they had the notice and the opportunity to be heard. They tried to be heard. Then they intervened after that, and I think it's also important to.
Well, they had notice, but they didn't have the opportunity to be heard.
Yeah,
but
exactly.
That's not really in front of us right now.
Right, but it is a part of of the law. I mean, we've been talking about that the whole time, that they have the notice and the opportunity to be heard, and therefore they don't get legal standing. I mean, it's all part and parcel.
The same trial court denied intervention.
That's correct.
Finding that they provided insufficient grounds. I mean, that just is. I mean, that's the trial court who conducted the hearing where they were present but didn't have an opportunity to speak also heard their intervention. And
yes, well, it was a motion.
It didn't deny it on statutory grounds.
That's correct.
Counsel.
Yes.
My concern, in our analysis, how should we take into consideration the fact that the agency removed the children from your client's care for being inappropriate and changing doctor's appointments and not cooperating with the child service providers? And if so, how's that to be analyzed, as well as what is your legal theory that gives you standing?
So I think that, let me take the first part, which is about them acting inappropriately. All it takes is for one perhaps angry or disillusioned caseworker to say whatever they want and make baseless allegations against people who never had the opportunity to defend themselves. It was never proven. It was just taking one person's word without ever getting to hear from my clients about their side of the story.
But as Justice Donahue, that should have been an appeal to Superior Court for an abuse of discretion. That's not. We're now here, you're trying to say that your client has a right to standing, a statutory right to standing, despite the fact that the child has not been in your client's possession for a couple years, and that this is an agency adoption, and the agency has removed the child from your clients based upon these allegations, which the court accepted. So we can only take the record as it is.
Understood.
So I'm asking you, tell me, how are we to consider that in our analysis as to whether you, your clients, I should say, have standing despite being out of control of this child for a couple years?
They should have standing because they have suffered a direct, substantial injury by removal of that child, as has the child. They were bonded. They lived together for 2 years. They raised this child since she was 1 month old.
How old's the baby now?
4.
Okay. So, and the pre-adopted, this new family has had the child an equal amount of time, correct?
Yes, Your Honor.
Okay.
Yes. There's no denying that, and unfortunately, we have to follow the courts. Obviously, are not a perfect system. Okay, and we're dealing
We're
with.
perfect, but you're right. Courts generally are.
Oh no, Your Honor, I'm not. I'm not trying to say that.
Kidding.
But you know, I was saddened to hear that it took so long to get a Superior Court decision. My clients were willing to jump in at any point. They've waited and waited patiently to try to get this child back into their lives, or at least have the opportunity to have standing in what happens to this child that they bonded with.
Yeah, but you didn't. Again, I mean, I think the only issue we took was a purely legal question. I think that's the only thing that we took. So I'm not sure how. I appreciate the background, but procedurally, though, your clients didn't move to intervene.
Well, they did after. So let me take a step back.
No, you got notice of the got notice of the hearing, right? Your
yes,
clients
but
got notice.
It wasn't to remove them. It wasn't for removal. It was for something. It was to terminate parental rights. That's what it was scheduled for.
So you never got notice of the decision to remove the child.
Yes, but not for that.
What was your earliest opportunity to intervene before the court to have your clients' arguments being heard?
Unfortunately, my associate had handled that, but
That's not a good answer.
Nope, I understand that. I believe, Your Honor, I believe it was early August.
I think I can answer this. August 26, 2022, there was a hearing, and at the end of that hearing, the court decided it was in the best interest of the child to be removed from your client's care, and at that time, your clients were there with counsel and did not attempt to intervene. So it seems like we have. Well,
we didn't take. I mean, we didn't take the intervention question about whether your clients moved quickly enough to intervene. So I mean, it's a little frolic and detour, but I'm trying to understand. I think I seem to understand their argument a little bit better than I did when I came in here. And the idea is that when the General Assembly passed this statute, this section of the code, then they intended through this language to basically be this is the code. It's a statutory proceeding. If you're looking for standing, it has to be in the code. If it isn't in the code, you don't have it. There's no common law, anything like that. These are statutory proceedings and it's in the code. That seems to be their argument. Your argument is no, there can still be all kinds of common law standing that we may have found beforehand. Why is your argument better than theirs?
because it's not clear and unambiguous based on the plain language, it does not say that the pre-adoptive or the adoptive parents, the prospective adoptive parents exception is stricken, or that we're not going to go by that. It doesn't say anything about that. So it's word soup. You're putting together an equation, okay? You're parsing apart the words themselves, but no matter how I put the words, as I read it, it doesn't explicitly.
Well, maybe our precedent was bad. Maybe. Oh, Superior Courts. Maybe Superior Court's precedent was bad.
That's an easier argument.
That's an easier argument. The Superior Court's precedent was bad because because we're never wrong. In most statutory proceedings, the General Assembly will choose who has standing and who doesn't have standing. And if the General Assembly hasn't given you standing, you don't have it. There's no way for us to, as a court, to wave a magic wand and give it. Maybe that's the mistake that the General Assembly was clarifying here is, oh, by the way, this is a statutory proceeding. These are the people we intend to have standing, and that's enough.
And that could be Your Honor's position. I don't know. But if you look at the plain language, it simply isn't there.
I agree. It's a clunky word. It's a clunky way of saying it.
It is. And the thing that I was laying in bed last night thinking about this is, what is the harm? Because we've heard arguments today about this is going to clog up the judicial system. It's been going on for decades, and I don't notice any change. I used to be a conflict parent advocate 15 years ago. The system's slow to begin with, unfortunately, and I don't think that the juvenile system has crumbled in light of this.
Well, regardless of all that, I mean, the legislature said nothing in this section. So unless you can provide us something in some other section that gives you standing, I don't see how you win.
Again, I think that if they wanted to be clear, they would have been clear. And I think that they left the door open for other instances because it's not an one size fits all. It's not in a box, and that it gives this court the permission to.
But counsel,
yes,
you said something very early on in your argument, and we've been sort of dancing around it. You said that your client has an interest in that child, and the legislature has apparently said not so. I mean, and other than the legislature saying that you do, your client certainly doesn't stand on the same footing as a parent who has a fundamental right, to the child's relationship. I'm grasping for where this right is that you're suggesting exists that gives you the footing to claim standing, if it's not statutorily created in this rather comprehensive statute that's been around for about 25 years.
Right. Well, I think it's conferred through, obviously starting before the statute, but then it's only confirmed through MFR in 2018. I mean, it's MRF.
But that's not our case. We don't care about MRF. I mean, we didn't decide that. That's the Superior Court. So,
I understand. I think that you asked me what is conferring it, and we continue to confirm what the court in Mitch v. Bucks with this prospective adoptive parent exception is. So that's why I come before this court to bring that to light and to give these folks, it's not the opportunity to be held higher on the in a hierarchy above a parent. That is not what we're saying. But they have the opportunity to have standing just in the narrow situation of when a child is removed from their care.
Okay, I think we understand your argument.
Can I just ask one follow-up question? I'm sorry, Chief. Is there a way to afford, as a matter of common law, to afford your client with standing without doing so contrary to what the General Assembly says is required for standing in this section?
Yes. I think that you could do it.
Could we give foster parents? Can we give foster parents standing as a matter of common law if they don't have custody without conflicting with the General Assembly's intent in this section?
I think that they can run alongside each other as they have.
Counsel, I'm sorry to press this point
It's
again,
okay.
but what is their interest? What is their interest? I mean, you went through the recitation of substantial, immediate, et cetera, in order to establish standing, but what is the interest? It's an expectation of a
Yes.
continued relationship, and where would that come from?
Well, Your Honor, when foster parents are as involved as mine are, or as mine were, they formed a very reasonable expectation that they were going to be adopting this child. And in fact, they were assigned an adoption caseworker. They were told that rights were going to be terminated on a date certain. There was an expectation formed over that course of 2 years, and then right beforehand, right before those rights were going to be terminated, all of a sudden the child was taken away from them.
But absent action by the juvenile court, that expectation does not become an entitlement, and the agency has custody, right?
The agency does have custody, but in the case law, it does state that if you can show that there is an expectation of adoption and it's reasonable, which I think under these circumstances, having this baby since birth for 2 years and being assigned an adoption caseworker and being notified about when the rights were going to be terminated, my clients formed a reasonable belief and an expectation that they were going to be the adoptive parents of this little girl.
All right.
Thank you.
Yes, thank you very much. And
Thank you, Your Honors.
Well argued by all. I have a question for Ms. Stryker. Is this your first appearance before the Supreme Court?
Yes, Your Honor.
And how long have you been with CYF?
For about 2 years.
Well, you did a very nice job, and you should tell your employer that we were pleased with your argument.
And they should watch it on
Yes.
PCN.
Yes, you all did a great job. Thank you.
Oh, 12.
Commonwealth of Pennsylvania versus William Albert Roberts. Representing Mr. Roberts, Mr. Matthew James. Representing the Commonwealth, Ms. Tracy P. Dowson.
Good afternoon. You may approach.
Good afternoon, Your Honors.
The appellant in this appeal was a lifetime registrant under the Sexual Offender Registration and Notification Act, or SORNA. We examined whether there was sufficient evidence to support his convictions under Section 4915.2A of the Crimes Code for failing to report to the state police any change in residence and to appear annually to verify his residence or be photographed. The trial court found that the evidence was sufficient to support his convictions. The Superior Court affirmed and held that the mens rea, or criminal intent element of the crime, requires the Commonwealth to prove only that the defendant knew of his failure to register or verify his address, but had no burden to prove that the defendant knew of his specific registration obligations. We must determine the propriety of the Superior Court's holding in that regard, as well as the court's ultimate conclusion that the evidence was sufficient to satisfy the mens rea element of the statute. Please proceed.
Good afternoon, Your Honors. May it please this most honorable court. My name is Matthew James. I am with the Fayette County Public Defender's Office.
Counsel, before you get going, you have a pen in your ear.
Thank you, Your
Take
Honor.
it out.
Oh, and also if you could, you're much taller than the previous counsel. If you could lean the mic up, bend it up a little. There you go.
Thank you. This case comes down to this court's and the courts below's interpretation of the knowledge requirement under A1 and 2. It appears that the Commonwealth and the defense agree that a particular defendant would need to know of his registration requirement. That's not what the Superior Court, in our estimation, held below. They simply stated that simply knowing that he didn't register would be enough. With regard to the specifics of this matter, there was a state trooper who testified that Mr. Roberts, he would have been given certain information. This particular trooper never met with Mr. Roberts. That was Trooper Adam Janosko. He stated that there were 3 particular state troopers, Megan's Law state troopers, specific state troopers, who had met with Mr. Roberts over the years, and that was over approximately a 12-year span. So Mr. Roberts had reported. He reported for more than 10 years, was excused in 2018 from reporting, but by all accounts, he had properly registered up until the year 2020. His position, of course, at trial was that he didn't believe he had to register. The Commonwealth did very little to prove, in fact, did nothing to prove that he knew of his registration requirement. As I stated...
So how would the Commonwealth prove that? How do you prove anybody's knowledge of the law?
And thank you for the question, Your Honor. With specific regard to this case and any other case as a whole, the Commonwealth, I believe, and we believe, that they had ample opportunity to present any state troopers who could have come forward and said, we specifically gave this information to Mr. Roberts, we specifically gave this information to a particular defendant.
Wait a minute, didn't he check the box that he understood this?
So, and thank you for the question, Your Honor. On pages 1 and 2 of the SORNA, of the registration requirements, there was no indication that Mr. Roberts was a lifetime registrant. What the testimony at trial was that Mr. Roberts was handed a packet. And not even that he was, I don't even want to misspeak on that point because it's important. It's that he would have been handed a packet.
But counsel, I apologize. My review of the record indicated that the Megan's Law packet was accepted into the record as Exhibit 2, which was a set of certified records from the PSP, which detailed your client's sex offender registration obligations as well as the required reporting history. How is that not sufficient evidence to indicate the mens rea of your client's awareness of his registration?
And Your Honor, as trial counsel, I can certainly speak on that. With regard to pages 1 and 2 of that packet, my client signed page 2. Page 2, up until that point, nothing indicated his lifetime status. Nothing indicated any sort of status. The packet as a whole was not sent out with the jury. The jury never got to see it. The jury didn't even consider it as evidence. So when we're discussing sufficiency, Your Honor,
Sorry, I need to back up. Did you say you were trial counsel?
I was, Your Honor.
Doesn't trial counsel have an affirmative obligation to notify his client upon conviction of what the penalty is, including the SORNA registration?
I was not trial counsel of his initial case. I was trial counsel for this specific case.
Yeah, but my point still remains the same. Doesn't counsel have an obligation, or the court at the time of sentencing, to notify him what his requirements are? And so after 10 years, well, I don't remember what happened 10 years ago, so I stopped reporting. What do we do with that? I mean, I'm just wondering why this is an error correction, or what is it we're being asked to decide here as the Supreme Court of Pennsylvania? We can't impute knowledge to every single defendant or make this a strict liability crime, can we?
And that's correct, Your Honor. This is not a strict liability crime in that it does require the knowledge element. But I'm not sure.
My question is this. Isn't that a question for the jury? And in this particular case, they answered that case in the affirmative, that they thought your client did have knowledge.
In certain regards, Your Honor, the Commonwealth could prove, of course, could prove sufficient knowledge. But what the Superior Court said below is that his knowledge that he did not register was enough to convict. That's results versus the nature of the offense. So what we're saying here is, what the Superior Court's saying is simply that he knew he didn't register. That's our reading of the Superior Court's opinion.
Counsel, I think you're right on that, and I think the Commonwealth agrees with you, and I think the Superior Court misstated that element of this particular offense. However, what you're now arguing really is error correction. The trial court got it right. The trial court said he had to have knowledge, and he did. He had forms that were presented to him every year, and they said he was a lifetime registrant. Now he says, I only had to register for 10 years, except he registered for 11 years. So the trial court got it right. The Superior Court arguably got the law wrong, and it's good that you brought that to our attention. But the second aspect of your argument really does go to error correction, does it not?
Your Honor, our position is that the Commonwealth didn't do, and specifically didn't do anything. Didn't do anything to show.
That's error correction. I mean, we took this case to determine whether or not essentially this is a strict liability crime. You're saying it's not a strict liability crime. The Commonwealth has to establish your client's knowledge of the requirements. Trial court agreed with you, as I understand what the trial court did here. The trial court tried this case on the basis that the Commonwealth had to establish knowledge, and found that they did. Now, see, if you disagree with that, that's a question of whether or not the evidence is sufficient to support that. Maybe you want to ask us to send it back for a consideration of that issue by the Superior Court, but that's not really why we took this case.
And I do understand that, Your Honor. My understanding is that I may also argue the sufficiency here as well, but I do understand where you're coming from on that note. But specifically, and of course the court knows this at this time, you took the case regarding the knowledge requirement, regarding strict liability offenses. What the Superior Court says is that Mr. Roberts would have had to be dead, in a coma, or otherwise incapacitated.
Right.
So what we're asking the court to do, of course, is to correct that notion, which is clearly wrong in our estimation.
Yeah, that's the interesting point, is that the Superior Court made a mistake here, but the Aplt, the Commonwealth, does not in effect defend their legal holding, just counterstates the issue as that the evidence was sufficient that your client knew. So that's why we're in this pickle here, because we took this because of the legal proposition on mens rea, but neither you nor you and the Commonwealth don't appear to disagree on the mens rea. You're just disagreeing on the evidence at this point, on the sufficiency.
In a sense, Your Honor, I don't want to speak for the Commonwealth, of course, and of course in reading their brief, I think there may be some minor discrepancies, but with regard to the evidence, I think what we have stated in our brief, not only that Mr. Roberts would have to be dead, in a coma, or otherwise incapacitated, but that's the Superior Court appears to be stating that, in our estimation, that Mr. Roberts, there was sufficient evidence, and of course we do disagree with that.
Okay, let me ask you this.
Yes, certainly.
Let's assume that you win on the issue that we granted allowance of appeal on, which is the Superior Court was wrong to the extent that they are explicitly saying or inferentially saying this is a strict liability crime. What do we do then? Do we send it back to the Superior Court? Do we remand it and say, take a look at the sufficiency of the evidence, because apparently, that's protected on the record, or can we decide that on our own, that the evidence was sufficient?
Thank you, Your Honor. And my understanding is that this court would be able to answer that question on its own for purposes of judicial economy, of course. Sending it back to the Superior Court would take up more of their time. A narrow issue.
Better theirs than ours.
And
Can I just get a point of clarification? Yes. Your client was sentenced under, at the time of Megan's Law 3, correct?
yes.
Did Megan's Law 3 have a provision like SORNA has right now about the notice during the colloquy where the trial court judge is supposed to notify the defendant of their registration requirement?
If I may ask a question in response, are you asking specifically during the initial registrable offense back in 2006, or are you asking specifically?
I'm asking when he was sentenced. SORNA today requires a trial court judge at the time of sentencing to also notify the defendant of his or her registration obligation. I was just wondering, was that provision in effect in Megan's Law 3 as well?
Whether or not it was, and I don't, of course, don't want to speak out of turn. Back during Megan's Law 1, he was sentenced, I believe, in 2006. Yeah. What that sentencing order indicated was that he would be, this is paraphrasing, he would be evaluated for Megan's Law registration requirements. The sentencing order stated nothing, and there was nothing in the record.
Well, it wouldn't have necessarily been. It would have been more in a colloquy format, not necessarily in the order. But okay, I was just kind of curious because if I'm the Commonwealth, and you may just be in a unique circumstance because your client's registration, was back in a prior version of the law. But today, this shouldn't happen because the trial court and the district attorney's office would be making sure at sentencing the defendant is aware of at least their view of what the registration requirement is.
And that's correct, Your Honor. That, of course, was not admitted at trial either. So when it goes to the sufficiency, what we're asking this court to do, we're asking this court to clarify the knowledge requirement, of course, and we are asking this court to make its determination on that sufficiency as well in Mr. Roberts' favor. Thank you.
Okay, thank you very much. Let's hear from the Commonwealth. Ms. Pietkowski?
Yes, thank you. Good afternoon. May it please the court, Tracy Pietkowski on behalf of the Commonwealth from the Office of Attorney General. I agree with counsel and with this court. I think the Commonwealth's understanding that the only issue here had to do with not the only issue, but the issue that this court took had to do with the knowledge requirement. And the Commonwealth is in agreement that in order to knowingly fail to complete some aspect of registration, an offender would have to know that he had to do it in the first place. So I think
means that you're conceding the Superior Court was wrong on the knowledge standard. You're not conceding on the evidence here, but you're
correct. I'm not conceding on the evidence, and I actually didn't read their opinion that way initially. I certainly understand why counsel did and why this court did, and having reread it, and prepared for argument, I certainly agree that this court needs to clarify that for the Superior Court. So I do agree with that. So that
to clarify, to suggest that it's not a strict liability crime, and the knowledge requirement is always one of the issues that the Commonwealth has to prove in order to secure a conviction for failing to register.
Yes, but I would point out that what the Commonwealth has to prove is that the offender didn't do the specific thing he is charged with not doing. So if the thing he's charged with not doing is his annual verification, then that's the knowledge the Commonwealth.
Well, wait a minute. He had to know. See, he had to know he was a lifetime reporter to know that he had to report. Otherwise, he wouldn't have had to report. So you don't want to backpedal, do you? I mean, the Superior Court couldn't have been right, could it, when it said, let me read you exactly what they said. They said, we find the statute does not require proof that Roberts knew of his lifelong registration requirement. That's a quote. How can that be correct if he... I understand your point that he did know, but they're saying he didn't have to know, and that doesn't seem to work because he had to know that he had to report in this case, and then to know he was failing to report.
Right. So So I don't want to be in the business of sort of defending what the Superior Court said, but I think
Why not? They want you to.
I think, well, because as I've already said, I do think the knowledge. I mean, I do think an offender has to know what it was he failed to do. But I think what they were probably getting at was this notion that, you know, the defendant in this case testified, I didn't know, I thought I was 10 year. And this was really supposed to be a sufficiency analysis. And the jury obviously rejected that. And I think where maybe the Superior Court tripped up a little bit in making that proclamation that Justice Wecht just read.
Imputing knowledge, that's a legal error, right, to impute knowledge here.
Well, I think the point there is that whether he thought, in his opinion, he should have to register for life versus for 10 years, is a separate question from whether or not when he failed to register after being notified that he was supposed to register, that he didn't do it. So I think that's a separate issue. So I don't.
But I just want to be clear. Do you agree with Justice McCaffrey that this is not a strict liability crime? Do you agree with that?
Yes,
Okay.
I agree with that.
And because can I be convicted of knowingly failing to send you a birthday card if I don't know when your birthday is? And there's a scienter here, right?
Right. No, and I agree with that.
You can win this case, in other words, even if the Superior Court was wrong. Am I correct about that?
In terms of their holding, yes.
Yeah.
In terms of the legal holding, yes, I think that's true.
This is just, it's strange that this is coming to us for a lot of reasons. But it's virtually impossible under SORNA, under any version of SORNA or any version of Megan's Law, for someone to come along and say, after being registered for a period of time, I didn't know what my registration was, because the Pennsylvania State Police is constantly notifying these people. They're constantly having contact with the state police. There's an incredible paper trail, and under at least the current version of SORNA, trial courts are required to do a colloquy. So I'm kind of getting to Justice Wecht's point, you know, hitting it a little bit harder is, how is this even a question? Of course they have to know, but the knowledge is all over the statute. The statute tells them what their registration requirement is. It's not just the trial court tells them, the statute tells them, the PSP tells them, probation and parole tells them, everybody tells them.
Right, I agree. Everybody tells them, which is why the jury in this case rejected the defendant's assertions that he didn't know, because there was all this evidence that he did know, that they could reasonably infer from that evidence that he did know. And yes, the statute is designed, it does have provisions requiring the court to notify a defendant of their registration requirements.
But that didn't happen here.
Well, we don't know that it didn't happen.
But you didn't prove it happened here.
Well, that's true, but we didn't.
Well, but that's your burden. I mean, Justice Brobson's point is the law as it currently stands, we wouldn't see this happen again because there's too much on the record notice that's given. But in this case, I mean, as I read the record, this was, he signed forms every year that said that he was a lifetime registrant. Oh, and by the way, now he says 10 years, but he'd been registering for 11 years. That's not the kind of notice that's all over the record. That's not what you proved.
He might just be bad at math, too.
Right. He may be bad at math. But again, this was a sufficiency question. So while it might have been helpful evidence for the district attorney to have introduced a piece of paper from the original sentencing that said he was provided with that information, the jury still could have found the evidence sufficient that was presented to prove that he knew he was still required to
And in
register.
defense of my point, the statute also says that the failure of the trial court to give the colloquy cannot be used as a defendant to avoid their registration requirement.
Right, and there's
So,
also a provision which...
My point was there's a lot built into this current statute that we wouldn't see this.
Right, and the way the Pennsylvania State Police administer it, as you said, which they're charged with doing, is to provide constant notice.
Which was happening here. The state police forms he signed specifically said he's a lifetime registrant.
Yes.
And he signed them.
He signed them.
But he went in to sign them. He saw them in the context of registering.
Right, so he certainly knew he was supposed to be registering because he goes in to register and then he gets his picture taken and he fills out a form and his signature says, I acknowledge I know what's on this form, and that form in this case did say he was a lifetime registrant and that he had to register.
No one is arguing against that point here.
Okay.
I mean,
Right.
you know,
Well, then I don't want to argue against myself. So
this comes down to the question on which we granted allowance of appeal, which you have conceded on. This is not a strict liability crime. We should have been the end of the discussion.
We all agree. It's just the Superior Court didn't agree, and that's why the case was taken. Because that's not what the Superior Court
right, that's not what the Superior Court held. I think a rule clarifying that would be helpful.
I am now turning off my lamp. That is a signal that we have heard enough. We understand your arguments.
Okay.
Thank you, Your Honors.
Very well done. Thank you. Mr. Minner will be adjourned until tomorrow morning.